Mention Lordship,
Lord, yesterday's matter, my lord. Lordship may, with liberty, my lord, to discharge. Yesterday's matter, seal number 33 in the second
listed
list.
today?
It is listed today.
All right.
Identical what other seal.
All right.
Your Lordship,
With
Give all the
liberty to
memos.
seek for discharge, my lord.
Give all the fresh memos.
Your Lordship, this
Wait.
this has not appeared.
One ನಿಮಿಷ.
Very good.
Yeah.
Any date?
Wait. ಒಂದ್ ನಿಮಿಷ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಪೆಂಡಿಂಗ್ ಬರೋಲ್ಲ. ಇಂಟರ್ ಮಾಡ್ರಿ ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, crime ಇದೆ.
ಒಂದ್ ನಿಮಿಷ.
My lord, we have invested.
ನಾನು ಮೆನ್ಷನಿಂಗ್ ಇದ್ರೆ wait madam. Settlement memos ಯಾವ್ದಾರು ಇದ್ರೆ ಕೊಡಿ. All settlement memos and write on the memo when do you want it. All withdrawal memos kodi, if there is any withdrawal memo. ಇಲ್ಲ ಇವತ್ತಿರೋದು withdraw ಮಾಡ್ತಿದ್ದೀರಾ? Withdrawal of those in the list or you want them to will? Now We'll send it to the coordinate bench only. Good. Which one, madam? Oh, correct. You want me to send it there? That I can't get here. Because of seniority, it will go there, we'll tag it to that. Tag madangre ಮಾಡ್ತೀನಿ ಕೊಡಿ. All right, yes. It's all right, sir. ಏನ್ fresh up pending ಹೇಳಿ. Fresh up pending. File an application. Yes. Next, file an application for that, whatever you need, passport, yes. Oh, so what? Son's marriage go case pending ಇರಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? You have taken money in performing marriage, ಇಲ್ವಲ್ಲ? ಮತ್ತೆ wait, Tuesday ಕೊಡಿ. ಅದೇ Tuesday ಕೊಡಿ, No, sir, Tuesday, yes. Fresh matter, Tuesday ಬರುತ್ತೆ ಕೊಡಿ. That law, it had come before me once. Give it. If it has not come before me, it will come on Tuesday. If it has come, it won't come. We'll see. Give it, yes. Give the memo. Give all the memos. Fresh matter, whatever it is. Give it. Give all the fresh memos.
Yes.
File an application for passport and then move the matter. Pending matter alva. Fresh passport ge application haki, one IA haki, we will pass orders. Don't get the pending matters by this method. Yes. ನಿಮ್ಮ ಹತ್ರನೇ ಇರ್ತೀನಿ ನಾನು, ಈ ಕಡೆ ಬರೋಕೆ ಆಗಲ್ಲ. Wait, yes. Wait. ಇಬ್ಬಿಬ್ರು ಹೇಳಿದ್ರೆ ನಿಲ್ಸೇ ಬಿಡ್ತೀನ ಎಲ್ಲ. ದಿನ ಹೇಳ್ಬೇಕಾಯ್ತನಾ? ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ತಾನೆ. ಎಲ್ಲ ಫಾಲ್ಸ್ FIR, ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಹೇಳಿ ಸರ್. Tuesday ಕೊಡಿ, ಎಸ್. FR ಆಗಿದ್ರೆ ಬರಲ್ಲ, ಸೀನಿಯಾರಿಟಿ ಮೇಲೆ ಬರುತ್ತೆ. ಗೋ ಅಂಡ್ ಕಂಪ್ಲೈ, ಎಸ್. ಸೊ ವಾಟ್? Tuesday. ಏನ್ ಹೇಳಿ ಈಗ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕಂಪ್ಲೈಡ್. So what? ಕೊಡಿ, ಎಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? Tuesday 6 months ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ಎಸ್. Give it. Take that tomorrow. Yes. Wait, 2:30. ಅದಕ್ಕೆ 2:30ಗೆ ಹಾಕ್ಬೇಕು. No problem. Let him come. Tomorrow, give it. Yes. 2:30 I can't take, sir. Tomorrow. Yes. How many of you speak at a time? Should I tell every now and then? Yes. Give it, sir. It will come on Tuesday on that, on maintainability only. Yes. Pressure pending, madam. Give it, yes. Tuesday. ನಿಮ್ದ್ರಲ್ಲಿ ಯಾವ್ದು ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ, ಕೊನೆಗೆ ಕೇಳ್ತೀನಿ. ವೇಟ್, ಎಸ್. ವೈ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಆಯ್ತು, ಗಿವ್ ಇಟ್ ಟುಮಾರೋ, ಎಸ್.
It's a pending matter. Lord.
Entry model ಇಲ್ವಾ?
Yes, my lord.
Entry model iಲ್ವಾ?
Entry model is there, my lord.
ಇದೆಯಾ?
We have settled the amount.
January
of breach of-
2025. Yes,
My
next.
lord, breach
No.
of agreement, my lord. We have settled the
Entry
amount.
model ಇದೆಯಾ?
Entry model
Settle ಆಗಿದ್ರೆ ಸೆಟಲ್ ಆಗಿದ್ರೆ
coming forward.
I am
my
not,
lord.
going. No, madam. Yes.
My lord, it's both fresh matters. Under the Land Grabbing Act, my lord, proceedings are initiated
Tuesday, sir,
against.
give it.
My lord, the matters on Tuesday,
So what?
for their presence, my lord.
Because of land grabbing court, I should take it.
Allah,
I
Allah.
should regulate my procedure.
Allah, my lord.
Then-
What's happened is that the petitioners, my lord, the complaint has been filed by some Tehsildar who is not even
Maybe
concerned.
on Tuesday, yes.
Is it possible tomorrow,
No,
my lord,
sir.
please?
Yes.
Fresh matter, my lord. I have moved memo.
Tuesday, yes, give it. Fresh matters, please give it for Tuesday. I'm not going to take anything tomorrow. Give it. Fresh matter. Pending. ಏನ್ ಯಾಕೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ? ಇಲ್ಲೇ ಬರುತ್ತೆ ಕೊಡಿ Tuesday.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಗೊತ್ತರ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು
ಹಾ?
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಬರ್ಲಿ ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ.
ಆಯ್ತು ಕೊಡಿ.
My lord,
Tuesday.
pen-
This is a press matter, my lordship. There is a matrimonial.com.
Tuesday.
Matter is there, my lord. Press matter,
Tuesday.
my lord.
Tuesday.
Please, eight times I filed the memo, my lord.
Even if you file 10 times, it is only on Tuesday. Give it.
Use one of the handicap, my lord.
Tuesday. Yes.
Please, my lord.
my lord, it's a pending my,
matter.
Pending matter, give the memos.
Based on 3 now application, accused is in JCM, 16/5.
Accused is in JC, why?
Works okay.
311 application JC go, 311 application allow ಮಾಡಿದ್ರೆ JC ಇಂದ ಆಚೆ ಬರ್ತಾರಾ?
ಇಲ್ಲ, ಅದು
ಮತ್ತೆ?
16/5/2020.
Why do you project all that?
16/5/2021 stay has been granted, list after.
ತಗೊಳ್ಳಿ madam. List that on Wednesday.
my lord,
My lord,
crime
crime
is
for
pending,
the-
my lord, and 22 stay was granted and after
You are for
that,
the respondent.
and we have invested 1.17
You are for
crore.
the respondent.
Yes, my lord.
ತಗೊಳ್ಳಿ madam ಹಾಕಿ.
My lord,
Tuesday.
5/6/21 ಇನ್ಸಿಡೆಂಟ್ ಡೇಟ್ ಇದರಲ್ಲಿ ಸರಿಯಾಗಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತಿಲ್ಲ, ಡೆತ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ ಮೇ ಬಿ
Pending
ಡೇಟ್ ಮೇ ಬಿ
matter.
ಗಿವ್.
Fresh matter.
ಇಲ್ಲ ಪೆಂಡಿಂಗ್ ಇಸ್.
Ending ಯಾವ್ದು ಬರಲ್ಲ madam.
Pending.
Criminal petition
Ending
two,
ಕೊಡ್ಲೇಬೇಡಿ. Huh? If it has come before me once, it will not come.
my lord, criminal petition two,
For me once and I have not granted interim order, it will come for admission, but not next week. Yes. If I continue, I'll take it. Yes.
Kindly.
I'm not there. Yes.
Special court matter. Sir, these accused, all the accused have been quashed, my lord.
19th, sir, give it.
Lord, fresh matter, my lord.
19th. Yes.
Kindly.
Birth ಕೊಡಿ ಯಾವತ್ ಬೇಕು ಅಂತ.
Kindly, your lordship, this pending matter, your lordship. This is the interim consideration of
madam.
interim prayer.
Will you wait? Yes.
Pending 23 matter interim order was granted subsequently in the next date.
June 2025, give it. Yes.
Not extended, please, my lord.
ಸರಿ ಅದು
Stating that
ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್ ನಾಳೆಗೆ ಹಾಕಿ.
But fresh matter,
Being
my lord,
spoken to ಹಾಕಿ.
fresh matter, my lord, offense under section 3.
Tuesday, give it, sir.
Kindly, your lordship.
There is some
Pending matter.
inconvenience for Tuesday.
ಏನು?
Personal inconvenience.
Personal inconvenience.
Wednesday.
So I have to adjust my court according to your convenience.
As-
ಅದು
check.
list after vacation. Yes,
Please
next.
check up.
Pending.
After vacation, sir. Yes.
Pending.
Don't take that memo. Yes.
It's a disposed of matter, my lords.
Ah.
My lords, I filed an application, my lords, seeking for a small modification of the order. The order would not change its,
ತಗೊಳ್ಳಿ
with
ಕೊಡಿ.
regard to interpretation of section 49, my lords.
Pending matter, my lord, interim consideration of interim prayer. your
Next
lordship.
Thursday.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
Stay ಕೊಟ್ಟಿಲ್ಲ sir.
ಕೊಟ್ಟಿಲ್ವಾ? ನನ್ ಮುಂದೆ ಬಂದಿತ್ತ?
ಮುಂದೆ ಬಂದಿತ್ತು ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಕನ್ಸಿಡರೇಷನ್
Husband.
ಇಂಟಿಮ್ ಪ್ರೇಯರ್ ಅಂತ.
Husband.
ಅಲ್ಲಲ್ಲ ಸ್ವಾಮಿ ಇದು ಬಂದು
ತಗೊಳ್ಳಿ
323 ಸ್ವಾಮಿ.
Give it, give it.
Next Thursday,
Kindly
because it's an
Tuesday,
MLA matter.
Kindly Tuesday.
No, Tuesday, give the memo.
Consideration of
No,
interim prayer,
madam.
your lordship.
No, yes.
Because my lord, that is only 323 offensive.
If I have granted for a few and not granted for someone else, it is
That is
definitely
one of the
non-grantable till the respondent appears. Yes.
SC/ST my lord, that is there. Already they
no
have filed the
problem.
wakalat, your
No
lordship.
problem.
Your
Yes.
lordship.
Yes.
Sorry, my
Next
lords,
week.
Okay. You have told, right?
I just
You
said
want to finish the argument now only?
MPMLA matter, my lords, Thursday. There's no urgency for Tuesday or Wednesday, Thursday and the.
Next Thursday ನೇ ಬರೋದು. ನೀವು ಬೇಡ ಅಂದ್ರೂ ಅವತ್ತೇ ಬೇಕು ಅಂದ್ರೂ ಅವತ್ತೇ ಬರೋದು.
As per the respondent, in this matter, the trial court 138 proceedings is pending from 2019.
Hmm.
The petition has filed the petition in.
Tuesday ಕೊಡಿ. Yes.
2021.
ಅಲ್ಲ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ.
Matter 2021 ಒಂದು petition file ಮಾಡ್ತಾರೆ, ಅದರಲ್ಲಿ entry ಮಾಡೋದು ಆಗೋದಿಲ್ಲ. Again, subsequently 2023 ನಲ್ಲಿ
ಮೇಡಮ್
ಇನ್ನೊಂದು-
ಅದನ್ನ post it on Wednesday in fresh matters list. Yes. Give it, give all the pending memos, sir. Give all the fresh matter ಕೊಡಿ ಅಲ್ಲ. Huh? Maybe, give it. Yes.
my lord, criminal petition 255 or 25, my lord,
ಏನದು?
for withdrawal, man.
ಇದೆಯಾ ಲಿಸ್ಟ್ ಆಗಿದೆ ಇವತ್ತು?
ಇಲ್ಲ, sir.
ಮೆಮೊ ಎಲ್ಲಿದೆ?
ಕೊಟ್ಟಿದ್ದೀನಿ, sir.
ಬಿಡಿ.
Fresh matter.
Yes. No, I am not taking, madam.
But passport authorities are not giving.
If file an application that passport authorities are not giving, then I will consider that application.
My lords, I may be permitted to make a submission, my lords. List 2, my lords, serial number 55.
Adjournment,
Not, my lords, I'm requesting to be taken up tomorrow in fresh matters. my
tomorrow,
lords.
why?
I'm an
It
ED
won't reach
officer.
today, is it?
My
Wait,
lords.
madam. We'll see when it is called.
30 lordship.
10 FIRs have been registered.
1 minute. Yes, sir. Next Thursday, sir. Next Thursday, ಅಲ್ಲ. Yes.
Under ITP, your lordship, 10 FIRs have been registered.
10 FIRs.
Same for the batch.
ಕೊಡಿ. Tomorrow ತಗೊಳ್ಳಿ.
It's proportionate asset.
Next week, kodi sir.
Specific date was given as 10/9. May I request tomorrow?
Another specific date is 29. Give it. Yes.
It's a fresh matter, my lord. Kindly
Okay.
post it for tomorrow.
No, Tuesday. Yes.
Tuesday.
Yes, Tahir.
But if the petitioner is seeking a release of interim release for his father, under trial father lordship,
Interim bail.
interim bail lordship. 230 I have
ಯಾಕೆ
maybe
ಅಲ್ಲಿ
maybe
GML
it's
move
not
ಮಾಡಿ
fixed. But in the under trial lordship is the.
under trial,
matter is
not
disclosed.
parole ಅಲ್ಲ, correct, ಆಯ್ತು.
Okay. So maybe on Tuesday also. if
I'll take
possible.
it on Tuesday. You serve the copy on
NI is the respondent lordship. I'll serve the copy.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ರಿ ಮುಂಚೆನೆ. Tuesday third.
Learned
ಈಗ ಹೇಳಿ.
magistrate have taken cognizance.
Mike.
Learned magistrate have taken the cognizance, my lords. The check is presented beyond the limitation, my lords. Hence, my lords, the.
Tuesday. Yes.
Tomorrow, my lords.
Why sir? Tuesday sir.
My lord, the matter was listed under admission yesterday, my lord.
FR number Avinash. FR.
My lord, the matter was listed under admission yesterday, my lord. It split up charge sheet ಆಗಿತ್ತು. Your lordship, when I sought for an interim order, ಒಂದೇ ಸತಿ dispose ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ರು. But interim order ಯಾವ್ದು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಅರ್ಜನ್ ಆಗಿದೆಯಾ?
ಅರ್ಜನ್
Split up.
Split up.
Wednesday ಹಾಕೋಣ. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
My lord, one matter for tomorrow, my lords.
Why sir?
My lords, my application under 311 proceedings under
Tuesday,
138
yes.
is rejected.
Tuesday. Yes.
Tuesday.
My lord, a date given matter for 11th, my lord.
No, sir.
It was not listed, my lord. It was a date given matter by this.
That's all right. Don't.
My lord, this is.
Interim order ಇಲ್ವಾ?
ಇಲ್ಲ, ಇದು ಟ್ರಾನ್ಸ್ಫರ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದ ಅಕ್ಯೂಸ್ಡ್ ಫ್ರಮ್ ಬೆಳಗಾವಿ ಟು ಬ್ಯಾಂಗ್ಳೂರ್ ರಿಪ್ಯಾಟ್ರಿಯೇಟ್ ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ.
ಬೆಳಗಾವಿ ಟು ಬ್ಯಾಂಗ್ಳೂರ್.
ದಿಸ್ ದ ದರ್ಶನ್ ಕೇಸ್.
ಬಳ್ಳಾರಿ ಟು ಬ್ಯಾಂಗ್ಳೂರ್.
ದಿಸ್ ಇಸ್ ಫಾರ್ ಅಕ್ಯೂಸ್ 14. ಬೇರೆ
ಬೆಳಗಾವಿ
accused.
ಹೋಗಿದ್ದೀರಾ?
ಬೇರೆ
ಆಯ್ತು.
ಅಕ್ಯೂಸ್ಡ್.
Fine. ಕೊಡಿ.
11th ಡೇಟ್ ಇತ್ತು.
Wednesday 18th ಹಾಕಿ.
Your lordship,
Gणेश?
respondent, 500 IPC though. I am 500 IPC. I am for the respondent. Kindly post it.
ಅದು ಹಾಕಿದಾರೆ ನಿಮ್ಮ ಮೇಲೆ?
Also.
ಕೊಡಿ.
Tuesday.
ನಿಮ್
Fresh.
ಸ್ವಂತ ಕೇಸ?
So respondent, sir. I am the.
ಆಯ್ತು ಸರಿ, ಓಕೆ.
Tuesday.
ಆಗಲ್ಲ.
Fresh matter, sir.
Thursday. ಫ್ರೆಶ್ ಹೊಸ ಮ್ಯಾಟ್ರ?
Also.
ಅದೇನ್ ಟ್ಯೂಸ್ಡೇ ಬರ್ಲಿ.
Tuesday.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀರಾ?
I am the respondent.
Huh?
I am the.
Wednesday.
Much obliged.
Petitioners, eight petitioners was remaining two, my lord. The maintainability has been right.
Next Friday ಹಾಕಿ.
Your lordship, this is a fresh matter, your lordship.
Tuesday.
According to seniority wise, ours is senior, your lordship.
ಆಯ್ತು, ಟ್ಯೂಸ್ಡೇ ಬಂದೇ ಬರುತ್ತೆ ಕೊಡಿ. If you are
Only-
senior enough, it will definitely come.
Only submission is regarding the address of petitioner. your
No more
lordship.
memos, Saku. You can't go finish every court and come to this court. I'll be taking memo up to 11 o'clock and stop. Yes, call the cases.
Fresh matter.
Call the cases.
This one, ink for
ನೋಡ್ತಾನೆ ಇದ್ದೀನಿ. Coming and moving, finish every court's case and come here. Yes.
Petitioner accused him, two crimes were registered, one is crime number 19 and one is crime. But please to grant the anticipatory bail, add entry anticipatory bail in crime number 38.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಇದರಲ್ಲಿ?
ಇಲ್ಲ, ಒಂದೇ ಒಂದು ಲೈನ್ ಅಲ್ಲಿ co-accused in the same crime ಅಂತ ಇದೆಯಲ್ಲ, anticipatory bail is granted in the other crimes.
ಎಲ್ಲಿ ಅದು? ವಿಚ್?
List this matter on 26/9 ಆದ್ಮೇಲೆ the third line.
ಈಗ ನಿಮ್ಗೇನ್ ತೊಂದರೆ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ,
ಆಯ್ತು.
ಸೇಮ್ ಅಂತ ಇದ್ರೆ ನಾನು ಮಿಸ್ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದೆ ಅಂತ ಅವರು ಆಮೇಲೆ
Oh.
that way it's difficult to.
Where do I get that?
List this matter on 26/9, 2024.
Owing to the aforesaid ages ಎಲ್ಲ ಆದ್ಮೇಲೆ granting and co-accused.
Same crime ಅಂತ ಇದೆಯಲ್ಲ, in
ಅಲ್ಲ,
the other crime.
ಇದನ್ನ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಮಾಡಿರ್ತೀನಿ. ಸೇಮ್ ಬದಲು ಅದ ಇನ್ ಡಿಫರೆಂಟ್ ಕ್ರೈಮ್, ಅದು ಡಿಫರೆಂಟ್ ಅಂತ ಆಗ್ಬೇಕು. ಸರ್ಕಲ್ ಮಾಡಿದೆ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್.
fresh matter, but two.
Lordships had indicated matter.
No. Nothing special about Prajwal Revana. We'll have it here only. Nobody will, I request the councils not to utter the name of anybody. And not to read anything. Tell me to read, I will read it myself.
19th Lordship said.
Because, no, 19, I know.
Fair place.
We day in and day out here,
No, I
POCSO cases. What is special about
Very,
this
very
man?
fair.
Yes,
No, I have, no.
yes. Allah, it's my indication.
No, I understand.
Yes.
Our professor suggested
No,
initially.
that's
not for-
Entirely in the discretion of the court.
That is why I only request the senior councils to
No, I understand.
not to utter anybody's name and not to read. If it is explicit, I will myself read.
Very
Tell me that's enough.
Very.
Yes, sir. Start.
19th Lordship said.
Good, bad,
In the 19th Lordship.
Three
matters. In fact, lordships indicated that
No,
19th.
if you want a 19, these are bail matters.
Bail.
If you want to start, you can start.
19th for lords, all the three of, we have been,
19, sir?
Agbo.
Yes.
charge sheet copy.
Yesterday we have got.
Yesterday you got it. It's only 4 volumes. Yes, sir.
For the purposes of bail. Right,
Purpose
yeah,
of bail, yes. No, I'm also considering only for the purpose of bail. So why, we'll not hold it in camera, we'll hold it here
Please.
on night. Yes. We'll list it on 19th.
Agbo.
Yes.
This 7th and 9th, serial number 7 and 9.
ಅದು
8 and 9.
8 and 9.
ಇವ್ರದ್ದು ಯಾವ್ದಿದೆ?
8
ಅದು-
and 9.
Serial numbers?
8 and 9.
2, 8, 9. All right. 2, 8 and 9. All on 19th. 19th in fresh matters ಅಲ್ಲೇ ಇದೆ ನೀವು ಅಲ್ಲೇ
Ag-
Yes. Yes, Bipin sir.
My lord, offense under section 499.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ?
ಇಲ್ಲ, fresh matter. Lord, section 202 has not been complied with, my lord.
Besides outside.
Besides outside, according to the complaint itself.
Hardship one memo for respondent. For respondent.
ಏನ್ ಕಂಪ್ಲೇಂಟ್ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಅವ್ರ ಮೆಮೊ ಇದೆ ಇದೊಂದು ತಾವು ನೋಡಿದ್ಮೇಲೆ
ಕೊಡಿ.
Okay, CK sir.
ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರು ಡಿಸ್ಮಿಸಲ್ಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. ನಾವು ಇಟ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಆರ್ಡರ್ಸ್. ಇಸ್ ಪೆಂಡಿಂಗ್. ಅದು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ತಗೊಂಬಿಡಿ. At page number 7, your lordship.
That has got nothing to do with this case. Here, my lord,
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ ಅಲ್ಲೇ ಹಾಕೊಂಡಿದ್ರು ಒಂದು ಅರ್ಜಿ.
this is not a legal point, my lord, which has.
ಅಲ್ಲದ ಹಾಕಿದ ತಕ್ಷಣ my hands are not tied.
Correct, that is there.
My lord, offense under section 499. This court has held that, my lord, section 202 is
Mandatory.
mandatory. The lordships have held that, my lord, it is mandatory.
ಕೊಡಿ.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಇದೆ.
ಏನು?
It is a special court. my
ಸ್ಪೆಷಲ್
lord.
ಕೋರ್ಟ್ ಇದೆ.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. ಈಗ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಒಂದೇ ಇರೋದು.
ಹೌದು.
ನಾನು ಮೊನ್ನೆನೂ ಕೇಳಿದೆ.
Yes,
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಒಂದೇ ಇರೋದು.
Yes, ma'am.
ಯಾವ ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡಬೇಕು?
My lord, that is a procedure,
ಅಲ್ಲ,
my lord, under section.
Deciding outside the jurisdiction in the normal circumstance to a learned magistrate is
Correct,
fine.
correct.
Now, this is the only court in the state.
Yes, ma'am.
What
My lord,
jurisdiction?
Though, my lord, it is only state, my lord, and only court, only court, and by a notification it has been done.
Hmm.
My lord, section, my lord, clearly says that has to be complied with.
Hmm.
Now, my lord, 202 clearly says after the amendment in 2006,
Hmm.
that, my lord, an inquiry is compulsory, whether it is
In
a
what
special.
cases, sir?
My lord, whether
in
it is whether it is, my lord, a
See-
special court or not.
See Chimanova,
Yes,
2022 Supreme Court.
Yes, ma'am.
It deals with the same circumstance. Not in all cases 202 would vitiate the inquiry, vitiate the proceedings. Because yes, adralli enayitu, it was a public servant who had registered the crime. Then the jurisdiction magistrate was, that is also a case of a special court.
Yes, ma'am.
Court said nothing.
But I will look into that, my lord, as on.
But idralli ಒಂದೇ court irodu.
Yes, my lord.
ಈಗ if I say this court is outside the jurisdiction ಅಂದ್ರೆ
Other than that also, my lord, by.
this is magistrate's court.
Yes.
It is not special. court.
Allah, this is also, my lord, a special court, my lord, which is a magistrate court. I understood, my lord, what.
ಯಾವ್ದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಫಾರ್ ಇವ್ರು ಅಲ್ವಾ? ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಹೆಂಗಾಗುತ್ತೆ?
Now, my lord, before the magistrate, they have gone and given a complaint. The sitting minister now,
Now who has taken cognizance?
my lord, the magistrate has taken.
That it will go on that ground.
Special.
If it is not presented before the special
Lord,
court,
it is a special court, my lord, magistrate is also.
ಅಲ್ಲ
how is it been declared to be a special court?
My lord, that is.
It's the court of session.
Both are.
Both are.
Yes, both.
Special
Triable
Special,
by magistrate, court shall be magistrate.
Yeah, where is it? Where is the notification?
notification.
Notification.
Notification is there.
Magistrate for what purpose?
There are some offences, my lord, are triable by magistrate.
Ithen 138
ಇಲ್ಲ,
ಮತ್ತೆ?
499.
499.
499 and 500. All right.
Because the issue was raised. Right of appeal has been lost if you go to the,
No, right of appeal is a creature of a statute. Statute ಅಲ್ಲಿ ಇದ್ರೆ ಇದೆ, ಇಲ್ಲದ್ರೆ ಇಲ್ಲ.
go to the sessions court, they loses one of the right of the appeal. Therefore, the
199, my
subsequently,
lord.
magistrate court also declared as a special.
Lord, section 199 also, my lord, says they can go, my lord, before the magistrate. The public prosecutor can file a complaint, my lord, before the sessions court.
That is there. Now. that is-
Now, which is the magistrate court declared to be a special court? Only one court or what?
Only one.
My lord, let them produce those documents, my lord, whether it is there or not. But now. matter has
ಏನ್
been-
defamation ಹೇಳಿ ಈಗ?
My lord, they say, my lord, my entire allegation is one political party, my lord, is, my lord, taking the money from the state, my lord, and utilizing it for the Lok Sabha elections. My lord, if your lordship may kindly see, my lord, page 15.
One political party, yeah.
My lord, in the state, now, my lord, the complaint has been given by the sitting minister.
Correct.
Now, my lord, we have stated, my lord, in the media that the political party, my lord, is utilizing the funds from here to a corrupt
It
practice.
is political party or this person?
My lord, there is a certain, my lord, allegation.
Where is the allegation?
Lord, page 15, my lord, page 15, that is a private complaint. The popular Kannada daily newspaper by name Kannada Prabha, my lord, Bhrashtacharadalli, so and so. My lord, subsequently, if your lordship may kindly see, Congress Sarkara Bhrashtachara ಮಾಡಿ.
Sir, ಒಬ್ಬರೇ ಲೂಟಿ ಹೊಡೆದಿದ್ದಾರೆ.
ಅದಾದ್ಮೇಲೆ ನೋಡಿ, if your lordship may kindly see, my lord, subsequently.
ಇವ್ರಿಗೆ ಬ್ರೈನ್ ಮ್ಯಾಪಿಂಗ್ ಮಾಡಬೇಕು.
Yes, my lord, it's the
ಆಗ
question.
ಎಲ್ಲೆಲ್ಲಿ ಎಷ್ಟೆಷ್ಟು ವಾಟ್ ಇಸ್?
My lord, now, my lord,
I'll tell you one thing. Of course, it's on a political arena. The individual mudslinging should stop.
yes, my
Fight
lord,
on
I totally.
policies.
My lord,
What
subsequently, if
is
your
all
lordship,
this?
subsequently, if your lordship may kindly see, it says that so and so party is indulging in.
Every party member is speaking everything about an individual person. Speak on policies.
Absolutely, my lord, I totally agree.
ಮಾಟ ಮಂತ್ರ
Non-stop mudslinging of each other. Washing dirty linen in public.
What we have stated, my lord, further is.
ಮಾಟ ಮಂತ್ರ
ಅಲ್ಲ, ಗೊತ್ತಾಯ್ತು, ನೋಡ್ದೆ.
ಆಡಿಸುವ ಚಟವಿದೆ.
ನೋಡ್ದೆ. If this is not defamatory, what else can be defamatory?
But now, my lord, therefore, my lord, first question would be, my lord, whether, my lord, inquiry, my lord, is held, my lord, as per section 202. My lord, on that, my lord, I will, my lord, look into that judgment and also, my lord, because, my lord, I was relying upon the judgment of your
No,
lordships.
202 inquiry is a must.
Must.
If the court is beyond the jurisdiction of the complainant.
Yes, my lord, your lordship, kindly
True,
see the
no
complaint.
problem. There are Supreme Court judgments on it, no problem. But this is the only court in the state to deal with these cases. How
Lord,
do you say it is
When
beyond?
it is a only court also, my lord, my humble submission, on that point, my lord, I will try to convince your lord.
ಮಾಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. But the contents are explicit.
My lord, on that point, my lord, I will try, my lord, as far as 202 is concerned.
202 you try.
Yes,
Otherwise, there is nothing on merit.
yes.
Difficult case on merit. Withdrawal of complaint ಯಾರು ಹಾಕಿರೋದು?
Withdrawal
Dismissal of complaint.
ಅವ್ರ
Allah, your lordship may kindly see the dates. Every 3 dates, my lord, the 482 petition ಹಾಕಿದ್ದೀವಿ. Before the matter could be taken up, my lord, their matter is being taken up. Every 3 days, 4 days, my lord, if your lordship may kindly see.
ಅದಾಯ್ತು, but look at this is not correct.
My lord,
If you
major
are
major
No,
allegation.
you tell me, if you are standing on this side and offending such action, how can you defend such action? Tell me.
My lord, now on the point of law, my lord. whether
Point
we-
of law, you tell me,
Point
we
of law,
consider.
that is why, my lord,
These are facts.
my lord, otherwise also, my lord, except for the first sentence.
No, what first sentence? ಬನ್ನಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ಗಟ್ಲೆ ಇದೆ. ಓದ್ಬೇಕಾ? ಓದಕ್ ಆಗದೆ ಇರೋದೆಲ್ಲ ಇದೆ.
What we have stated, my lord, is against the political party.
Oh,
saying
not,
that, my lord, they are-
if that was the thing, I would have stated it immediately. It is not against the political party.
Yes, my lord, on
You
the
have gone
legal,
on the individual.
on the legal
This is
point.
what I'm saying. Nobody is going on the political party, all against individuals. Be it this party or that party, I'm not saying that, all against individuals. How much of mudslinging will you do?
Yes.
Yes,
My lord, on the legal point, my lord, I will try to, my lord,
legal point you do, yes.
because, my lord, in view of this judgment, my lord, where your lordships have held, since it is a special court, my lord, I will try to, my lord, convince. you.
ಅಷ್ಟೇ, 19th ಹಾಕ್ಲಾ?
But till then, my lord, let them not, my lord, ಇಲ್ಲ.
19 ಬೇಡ, ಇದು ಆರ್ಡರ್ಸ್ ಹಾಕೊಂಡು 2 weeks.
Why Ahmad sir?
ಇಲ್ಲ ಕೇಳಿದ್ದು 2 weeks ಇರೋದು.
ಯಾಕೆ 19th ಬೇಡವಾ?
19 20 ಅಲ್ಲ, ಆರ್ಡರ್ಸ್ ಆದ್ಮೇಲೆ ಹಾಕೊಂಡು ಅಲ್ಲಿ 199 ಮೇಲೆ
ಅಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಏನು ಆರ್ಡರ್ಸ್ ಬೇಡ.
Yes, my lord.
19th, I will myself pass the order here.
20th
ಯಾಕೆ ನೀವಿರಲ್ವಾ 19th?
19th ಒಂದು ಬೇರೆ ಮ್ಯಾಟರ್ಸ್.
ಈ ಮ್ಯಾಟ್ರಿಗೆ ಬನ್ನಿ.
ಅಲ್ಲ,
ಎಸ್, ಐ ಟೇಕ್ ಇಟ್ at 4 o'clock ಬನ್ನಿ. ಎಲ್ಲ ಮ್ಯಾಟ್ರ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ.
ಹಾಗೆ
ಎಸ್.
Lord, may I
ಕನ್ನಡ-
request, till then.
ಕನ್ನಡದಲ್ಲಿ ಎಲ್ಲ ಇವರಿಗೆ ಸರಿಯಾದ ಹಿಡಿತಾ ಇದ್ರೆ ಈ ಭಾಷೆ ಬರೋದಿಲ್ಲ. ನಮ್ ಕೋಪವನ್ನು ವ್ಯಕ್ತ ಮಾಡೋದನ್ನ ಭಾಷೆ ಬಳಕೆ ಬಂದ್ಬಿಟ್ಟು
ಇರ್ಲಿ, ಪರವಾಗಿಲ್ಲ, ಅದೆಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಬಳಕೆ ಮಾಡೋದು ಬೇಡ. ನಾನೇ ಓದ್ಲಿಲ್ಲ ಅದನ್ನ,
ಕರೆಕ್ಟ್.
ಮತ್ತೆ ನೀವೇನು ಹೇಳ್ತಾ ಇರೋದು? We'll do it on 19th, but this is definitely not in good taste and on the face of it defamatory.
My lord, I will, my lord, try to convince on the.
See, now we will see a spate of defamation cases that are filed. Why? They're all mudslinging each other.
Yes, ma'am.
ಬೇರೆ ಕೆಲಸ ಎಲ್ಲ defamation. And it definitely amounts to defamation.
Yes. Lawyers are very happy.
That is true. Lawyers are very happy ಅಷ್ಟೇ. Yes,
But
yes.
the matter is there today, my lord. Let them not pass any orders, my lord, till the next day.
List the matter on 19th. The concerned court shall defer its proceedings till the 19th.
Obliged.
ಮತ್ತೊಬ್ರು
19th ಬರ್ಬೇಕಾ ಮತ್ ಸರ್?
ಬರ್ತೀನಿ
ಇಲ್ಲ ಅಂದ್ರೆ ಅಲೋ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಅಲ್ಲ ಬರ್ತೀನಿ ತಮ್ಮ ಮುಂದೆ ಒಂದು ಅವಕಾಶ ಸಿಗದೆ ದೊಡ್ಡ ವಿಷಯ ಬರ್ತೀನಿ.
ಎಲ್ಲಿಗೆ?
ಇಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡೋದಕ್ಕೆ
ಹಂಗೆ.
ಬರ್ತೀನಿ.
My lord, serial number 4, 5 and 6. The matter, my lord, where dharnas have been held. Offense under section 188 and 290. My lord,
ಯಾವಾಗ ಇದು ಪ್ರೀ ಎಲೆಕ್ಷನ್ ಪೋಸ್ಟ್ ಎಲೆಕ್ಷನ್?
Pre-election. My lord, 195 1A, my lord, has not been.
Jagdish will have serious objection to these petitions.
Yes, now he'll have, my lord.
Now he has to have.
Raise that objection in coordinate bench, my lord. Page 59, my objection has been over.
Stay ಇದೆಯಲ್ಲ?
Illa, my lord, fresh matter.
Fresh matter. Learned additional SPP is directed to accept notice for the Ibru ಅಲ್ಲ?
Both respond.
For both the respondents. List the matter on 26th, there shall be an interim order of stay for the proceedings where these petitioners
Page
still in.
59, my lord.
Huh?
Page 59, coordinate bench.
Covered. Closer
Covered.
ಮಾಡ್ಬಿಡಂಗ.
195 1A, my lord.
ಬೇರೆ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ ಯಾರು
ಇಲ್ಲ.
Madam, all three ಅಲ್ಲ ಬಿಪಿನ್ sir?
Yes, my lord.
I think what the same case.
3, 4, 5. The petitioners are before this court calling in question so on. So the learned counsel Bipin Hegde appearing for the petitioner would submit that the issue in the list stands answered by the judgment rendered by the coordinate bench and that of this bench in page 59. No? The coordinate bench considered has has quashed the proceedings qua the other co-accused in the very same crime.
Allah, same accused Allah.
Same accused alva?
Same crime Allah.
Has quashed the proceedings. Quashed the proceedings of identical offences against other accused. The coordinate bench is held as follows. 195 bar ಅಂತ ಅಷ್ಟೇ ತಾನೆ?
Yes, ma'am.
188 ಇದೆ. 195 bar ಅಲ್ಲ ಇದರಲ್ಲಿ. 188 ಅಲ್ಲಿ in fact the coordinate bench not I argue and say that the 188 ಗೆ coordinate bench takes one step forward and say just mere disobedience is not needed. Something more is required.
Yes, ಇದು ಆಮೇಲೆ ಇದನ್ನ ಕೊಟ್ ಮಾಡಿ ಎರಡನ್ನು. ಮಾಡಿ close all the three. Yes. No, these small cases should not remain at all. Yes.
7, order 7.
Petitioner, respondent number 2 is the flying squad.
You serve on Sharad Dodwad. Counsel Shri Sharad Dodwad is directed to accept notice for the second respondent petitioner to serve set of papers upon the aforesaid learned counsel forthwith. 26th interim order continues till then.
Pledge.
Next. 8 and 9 adjourn agala. Uday.
Serial number 10, filed Wakalat this morning, my lords.
This 499, huh?
Howದು Swami? So, because
I told you, every week 10 cases are coming, defamation.
This is only a case where my lords, pass issued by the complainant to the smoke canisters only made a statement saying that if they are treated as anti-socials, then what will be the person who has issued the
please,
pass
my
is
lords,
only
I shall
coming to me.
produce this thing per se, all the this thing that the speech that has been made is per se defamatory. I don't want to read it out in the open
You
court.
produce, you file your objections.
Please, my lords, a copy may be directed.
I'll.
The learned counsel for the petitioner shall serve. The first barcode, learned counsel so and so, you have already filed or what?
I filed my Wakalat.
Learned counsel submits that he has entered appearance for the respondent complainant, registry to print the name of so and so as appearing for the respondent. Yes, we'll take it on 26th.
Please, my lord.
You file your objections by then. What's the next date?
It was yesterday.
It was yesterday, my lords.
Andre on 4 weeks hogirutte bidi.
Please.
Yes, and if there's anything, you move the matter before 26th. Yes, list on
9,
Huh?
25th.
25 9, Angar 19th.
9.
List on 19th. By then you file.
Please, my lords.
Oblige.
11.
It's a charge sheet which is being filed for wrongful restraint, unlawful assembly and criminal intimidation, my lords. So the facts is, my lords, petitioner
Office objections.
My lords,
My lord.
to be overruled.
The, my lord, office objections 1, 2, 3, my lord. Age, address, all of that is from the charge sheet itself.
Hmm.
So that may be
All right.
overruled,
The other
my lord.
ones?
The 4 offenses to be mentioned correctly at para B, we have mentioned the offenses which he was discharged of, I mean, the ones that remain, he was partly discharged.
Okay.
So the ones that remain, that's why they've raised that. Only para,
Now, what's the urgency? Yes.
urgency, my lord, it's on 18th/9. So it's for
18th/9.
for
All right.
charge.
Basic ingredients
Tell
itself
me.
would be lacking.
Tell
My
me.
lords, petitioner, my lords, first petitioner is an MLA, my lords.
All right.
Now, the complainant would say, my lords, he had put some derogatory things in the Facebook against the petitioners. So his case is that he was summoned, my lords, he was called to a place. And at that place, A1 and A2 would take him to a room and scold him, criminal intimidation. Now, on that basis, my lords, 4 days later, he goes, gives a complaint. And now the charge sheet is for 342, 149, my lords, 504, 506. 342, my lords, is covered by my lord's decision, my lords. When it comes to wrongful restraint, it should be a total restraint. It can't be a case where you take a person to a room, he has an opportunity of walking out. Like in this case, he walks out, my lords. So 342 doesn't apply. 149, my lords, an assembly of 5 persons itself is not there. Only 2 persons, my lords, who have spoken to him and who have reprimanded him for putting derogatory message in the Facebook. So both the ingredients, my lords, would not be made out. To be from the other political party. my
ಅಲ್ಲಿ
lords.
ಆಗ್ತಿರೋದೇ ಅದೇ.
ಅದೇ.
ಏನ್ ಬೈದಿರೋದಿದ?
I'm sorry.
Page 26 ಅಲ್ಲಿ.
ಹೌದು, ಹೌದು.
Those 2 lines.
Those 2 lines.
ಏ ಮಗನೇ ಅದ? Huh?
Criminal intimidation. And then, my lords, he says he walked outside. After 4 days, I went and gave this complaint.
Petitioners accused 1 to 7 are knocking at the doors of this court, calling in question registration of, calling in question the proceedings in CC 28585 of 2023 for offences punishable under section 342, 504, 506 and 149 of the IPC. If there are only 2 persons, one nimsha, nimgala. If there are only 2 persons, why are 7 petitioners here?
My lords, what they did is in the charge sheet, my lords, they named 7 persons. But even in the charge sheet, the allegation is, my lords, A1 and A2 are the ones who spoke to him. How could it be an unlawful?
Even in the complaint, it is only 2?
Complaint 3 persons and unknown people. Complaint only. But if the complaint is in A1, A2. If the complaint is in, my lords, may kindly
All right.
notice the complaint.
The second respondent is the complainant. A complaint comes to be registered on 30th July 2020 on the allegation that the petitioners have posted derogatory statements upon the complainant.
The other way around.
Allah,
Complaint goes, say,
the complaint comes to be registered that the second respondent complainant had posted certain derogatory statements on accused 1 and 2 on the social media -Facebook. Therefore, the accused 1 and 2 or even 3 had restrained the complainant in a particular room and had intimidated him. Therefore, the offense under section 342 and 504 and 509, including 149, have sprung. The learned senior counsel Sandesh Chowta would take this court through the summary of the charge sheet to demonstrate that the allegation against these petitioners, allegation in the case at hand was that there were only 3 persons. If it was 3, it cannot meet the ingredients of section 149 is a submission. The matter would require consideration. What merits acceptance at this juncture is the very offense under section 342 not being met in the case at hand. Section 342, which deals with wrongful restraint, has its ingredients in section 339 of the IPC. Section 339 mandates that the person who is restrained should not be permitted to move in any direction. It is only then it would become an offense under section 341. The complaint itself does not narrate any such instance at the hands of the petitioners upon the complainant. The complainant himself has walked out of the room later. Therefore, the offense under 342 is loosely laid against the petitioner. The intimidation, the criminal intimidation that is alleged of offense under 506 has its ingredients under section 503 of the IPC. The ingredients of section 503 can be seen to be hardly met in the case at hand. Therefore, there shall be an interim order of stay of further proceedings, qua the petitioner till the next date of hearing. One additional SPP 2 emergent notice returnable by the 26th.
HCGP.
HCGP, sorry. Yes. Returnable by 26th, yes.
Next matter is,
One more.
next
thought
matter
what-
is even worse, my lords. My lords, CM's convoy goes at Yadgir district, my lords. 15-20 persons come in front of the convoy. And in front of the convoy, my lords, they say, Guru Mittal Youth JDS ki Jai. Police would disperse them. Then comes this complaint. And a charge sheet would be filed. Offenses are again 143, 147.
Ella 2020 idu.
Howdu, my lords, ಎಲ್ಲ 2020.
Learned HCGP 1,
Please, ma'am.
additional SPP, sorry, emergent notice 2, returnable by 26. In the meantime, there shall be an interim order of stay for the proceedings by the petitioners. ಎರಡರಲ್ಲಿ ಒಂದೇ order ಬರೆದಿದೆ.
Obliged.
Next, yes.
13?
The order will take effect after compliance with the office objections.
Yes.
Yes.
Prefer 1 week time to remove the office subjects.
List on 26th, the office objections be complied with in the meantime. Next.
On IA 14?
14, please, my lords.
Then interim bail.
Same, everything out of the same first,
ಮೊನ್ನೆ ಕೊಟ್ಟಿರೋದು ಅದೇನಾ?
first serial number 1, ma'am.
This man is also 70 years old, petitioner. Same
On
court,
age parity or seeking or what?
70 years old. But, 26.
Same crime,
Same crime. But after 20 years, my lord, the complaint
ಇದು
is-
SJK. Serial number 1 ಇತ್ತಲ್ಲ, being spoken to. Same copy first now. Yes, so on. Yes.
Disaster Management Act, my lord, covered by decision, my lord.
51B, ಕೊಡಿ judgment ಅಲ್ಲಿ.
I have appended, my lord, page number 44, my lord.
Page number
This was quashed insofar as accused one in the same case.
Petitioner is before this court so and so. The counsel for the petitioner submits que accused number 1, this court quashed the proceedings in criminal petitions on page 44 in that light. So on so. Yes. Next. Heard, reheard, ಕೊನೆಗೆ ಇಲ್ಲೇ ಬರುತ್ತೆ.
ಇಲ್ಲ.
It's traveling with me. ಧಾರವಾಡಕ್ಕೆ ಹೋದ್ರು ಬದಿ. Yes. ಹೇಳಿ ಸರ್.
The petitioner Muda was working as an assistant commissioner Muda for a period of 1 year.
Synopsis ಹಾಕಿದ್ದೀರಾ?
Synopsis ಹಾಕಿದ್ದೀನಿ.
All right. ನೀವು ಹಾಕಿದ್ದೀರಾ?
ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಹಾಕಿಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ವಿ.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ? ಹೇಳ್ಬಿಡಿ.
That in brief, Muda, what would
ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಹೇಳಿ.
Yes. That what would happen is Muda, like complaint, the RBI Muda realizes that there's something Muda hanky-panky going on with IM. They would direct Muda the DG and IGP as well as Muda the DCP East Muda to investigate. They would submit a report saying that Muda there everything is correct, there's nothing going wrong with IMA. Therefore, there is nothing for us to take action. Then Muda government of Karnataka writes a letter to the deputy commissioner to direct Muda the assistant commissioner to lodge an FIR. Muda, after all of this, Muda, I am transferred to that post, I take charge, and then Muda, I give a complaint to the police station. The police Muda would reject my complaint and say we cannot register an FIR, there is no complaint made by anybody. I would write to the commissioner would also reject my complaint. Then, my lord, I issue a public notice. Nobody has come and given, my lord, any complaints. Then, my lord, I would request the IMA to give a report. They would give me a report. I would request the government, my lord, what should I do on this? Then, my lord, the government would appoint me as a competent authority.
Yes, later.
Later, my lord, they withdraw that authority, my lord, saying that you are no more the competent authority. Then, my lord, they would write to the government saying that, see, these are the reports that are given to me. DC has written to close the complaint. Therefore, I am forwarding this to you. And in that letter, my lord, which is now, my lord, the crux of the matter, I would pinpoint all the government orders and letters of the deputy commissioner and the government and say, this is the communication received. I am forwarding it to you for your further action. I am closing it at my stage.
That's all the allegation.
That is all the allegation. Then, my lord, a complaint is given by an unknown person to Commercial Street Police Station, and then, my lord, matter 73 is crime number 73 is registered by Commercial Street. That is now, my lord, transferred to the Central Bureau of Investigation.
No, is this the same case where the other IPS officer was also?
Yes, my lord. It is on his report that I close it at my stage.
IPS officer quid pro quo ಇರಲಿಲ್ಲ.
Quid pro quo ಇರಲಿಲ್ಲ, ಏನೋ ಸೋಫಾ ಸೆಟ್ ತಗೊಂಡಿದ್ರು
Sofa set ತಗೊಂಡೆ, ಅದಕ್ಕೆ ಮೆಟೀರಿಯಲ್ ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳಿ, not then I consider it.
ಅದೇನಾಯ್ತು, ಫೈನಲ್ ಆಗಿದೆಯಾ?
Now not it is pending in Supreme.
ಸ್ವಲ್ಪ ಹಾಕಿದ್ದೀರಾ ಆಲ್ರೆಡಿ.
Now, my lord,
ಏನಿಲ್ಲ.
what Commercial Street Police Station registered is transferred to CBI. In the meantime, ACB registers one more complaint. My lord, that is never, my lord, transferred to the CBI. CBI, my lord, would assume that all complaints are transferred to us, and therefore, my lord, we will take over jurisdiction and investigation of this complaint also, which is registered with Anti-Corruption Bureau. Registers, my lord, the separate FIR. Takes into consideration, my lord, the investigation done by ACB. And ACB had not obtained, my lord, prior approval under 17A. The CBI, my lord, would look into all those materials which are prior to 17A, take that into consideration, and then, my lord, file the charge sheet. In so far as, my lord, IPC offenses, the competent authority, my lord, has not granted in so far as section 218 of IPC, charge sheet is laid for that also. And, my lord, in so far as I am concerned,
218 ಯಾಕೆ ಬರುತ್ತೆ ಈಗ? 197.
197.
218 IPC Act.
IPC, ಎರಡು FIR ಇದೆ, ಒಂದು IPC, ಒಂದು PC Act.
All right.
Now, my lord, in so far as that is concerned, sanction, my lord, I have raised the contention that I am a Group A officer, cabinet. In the reply, specific government is, it is not granted by the cabinet.
Where is that?
Your lordship, kindly have a look at the statement of.
Kumar objections.
ಹೌದು.
Memo documents objections.
26.
ಅದು ಎಲ್ಲ ಎರಡು ಹಾಕಿದ್ದೀನಿ.
But 26 of the reply statement, para 31. Para 31.
Objections. Objections. Statement ಕಾಣ್ತದೆ. Synopsis. Let's check this. Reply statement is not there. Para 31.
I've noted it in my synopsis.
All right.
But the quid pro quo.
So it is admitted that
It is the chief minister, madam, on the last date of hearing, the lordship may not pose the same question to me. The competent authority may not or present with the original file, where chief minister may not had signed.
Yes,
With
yes.
not, they had also brought the rules not for your lordship kind consideration.
transaction business rule.
Transaction business rules ಅಲ್ಲಿ, both in Kannada and English, where may not the chief minister or he is the competent. Your lordship
ಕೊಡಿ ಅದು ಮೇಡಮ್ ಅದು.
It was brought by the sanction.
I think I saw the file also.
Please, your lordship was pleased to see the file and send it back. Now, my lord, he is contending that his earlier contention was chief minister should have given. When my lord file says chief minister has given, now he is contending that cabinet should give.
I can't go beyond what the rules say.
I know, we'll see.
irrespective of what I.
So whatever you say is not what is important. What the rules say
What
would be
the rules
important.
say.
Yes, let's see.
That the quid pro quo that they say, my lord, in 164 statement, my lord, in graphic, what they would say is that while I'm sitting in the office, my lord, somebody from IMA would come. In graphic detail, my lord, I would raise my hand, my lord, and tell them, hello. For that, my lord, since I show 4 fingers, I have demanded 4 crores as the statement.
ಹೌದಾ?
There are 164 statement of 3 persons, not one.
ಒಂದೊಂದು ಫಿಂಗರ್ ಒಂದೊಂದು ಕ್ರೋರ್.
That is the allegation again.
Yes, Prasanna Kumar.
Not your lordship, kindly, may not, in the statement of objections, the primary allegation is.
ಇದೆಯಾ
not-
ಮೇಡಮ್? Objections ಇಲ್ಲ. ಕೊಡಿ
This was filed, not may I just pass on.
ನಿಮ್ದು ಕೊಡಿ ಪ್ರತ್ಯೂಷ್.
Page 207, annexure R15. R15, my lord, page 207.
Notification.
Notification, not wherein under order notification dated 1/2/2019. The powers of the Assistant Commissioner as the competent authority was withdrawn. It was not handed over to Deputy Commissioner.
All right.
But even after withdrawal of this, not kindly come to the next annexure. Not 1 month and 6 days there, 1 month, 7 days thereafter. Not the petitioner, though he was not the competent authority, not he would send the report at page 209.
Saying what?
Not saying, your lordship will find in the next page.
No action can be taken.
No action can be taken against company under so and so. Not this is not his.
That's all against him?
No, this is the report that he gives, not the case against him is, not when he being the competent authority, when RBI may not refers a complaint to him, not he was required to inquire into the allegations. What he does, not he being the inquiry officer, not he will examine the accused number 1. He will examine his officers and conclude that there is no violation of the provisions of the KPAD Act. But you should have not inquired what is the business module. If you are taking 100 rupees, how you are giving 8% per annum or 6% per month every day? Where do you invest money? All that he has not done anything.
No, that's all right. But he has sent this report after the notification was withdrawn.
No, that is one. Secondly, your lordship may also have looked at the memo with document that I have filed. At page number 39. Now this is the cash flow chart, not downloaded from the
39.
iCloud. Page number 39, Mila. A memo with documents ಹಾಕಿದ್ದೀನಿ ನಾನು ಅದರಲ್ಲಿ. 39 ಅಲ್ಲಿ, this is the one not part of the charge sheet. Your lordship may kindly come to page 49. 49.
Yes.
ಅದರಲ್ಲಿ serial number 15, 1.5 crores to DC.
49.
Page 49 ಅಲ್ಲಿ.
ಈ ತರ ಇದೆ.
ಇದು ಮಾತ್ರ ಇದೆ. 1.5 crores to Deputy Commissioner.
DC ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
DC ಇಲ್ಲಿ ಲೆಫ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಸೆಕೆಂಡ್ ಕಾಲಮ್. MMK DC. Then not kindly
Who is
come.
DC? He is not DC.
He is not DC. Not AC ಮುಂದೆ. Then kindly come to page 57. Other expenses, LC Nagaraj, handed over by Nizambaiah, 2 crores.
1 minute.
Page 57. Serial number 620. ಇದೊಂದು. Then not kindly come to page 60. This Nizam also not has given one
Statement,
164 statement. Then not page 60. 431. Other expenses, LC Nagaraj, Wasim Bro, 50 lakhs. Then not page 62.
61 ಅಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ.
16 ಅಲ್ಲಿ 60ರಲ್ಲಿ
ಮಾರ್ಕ್ ಮಾಡಿ.
66.
ಆಮೇಲೆ
Then not 62.
All right.
Not date and time not has been given. In all, 5.5 crores has been received not by this petitioner. Total.
ಅಲ್ಲ ಇದು ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್?
ಇದು this is the statement maintained not by the co-accused, not in his iCloud, which has been downloaded, and his 164 statement not has been recorded.
164.
This was entered
Where is
at an
the
undisputed point in time. 164 statement your lordship will find not from page 84 onwards.
Where do you get this figure?
50 lakhs your lordship will find this Wasim Nazimuddin, page 84 it starts. At page 89.
No, this 164 statement ನೋಡಿದ್ರೆ there are more skeletons in the cupboard.
Of course. Whoever may not.
Not only this, we have spoken about everybody.
Of course. Then page 89. 9 para 2. And after about 6 lines from
When
the
huge number, Radha.
simultaneously he sent me.
Simultaneously, okay.
Sent me to LC Nagaraj, who was Assistant Commissioner, and published the above notification. I met LC Nagara and submitted the LLP and financial documents and came back. After 1 week, Mansoor Khan asked me to go to him and talk about our files and get his contact number, which I did. After 2 days, Mansoor Khan asked me to go to DC office and wait there. I was waiting there. Suddenly, so-and-so brought a bag of cash containing 50 lakhs. Then, Mila, kindly also come to page 92. Para 3, Mansoor wanted to so-and-so. There, Mila, he speaks about handing over 2 crores. In page 92, handing over Mila, 2 crores to his assistant Manjunath.
92, which paraset?
Para 3.
Paragraph.
Mansoor wanted to settle matter with LC
Mansoor wanted to
Nagaraj.
settle. All right, yes.
Assistant Commissioner and paid rupees 4.5 crores 2018-19. Now, this is one statement. Then on page 94, Nizamuddin.
164 statement.
Is 164 statement. Then what is actual statement starts from page 97. Relevant at page 98, Mula. After about 5 lines from the top. ನಂತರ ಮನ್ಸೂರ್ ಕಾರ್ ಅವರು ನಾನು LC ನಾಗರ್ ಅವರನ್ನು ಮೀಟ್ ಮಾಡಲು ತಿಳಿಸಿದ್ದರು. ನಾನು ಸೂಕ್ತ ದಾಖಲೆಗಳನ್ನು ಅವರಿಗೆ ಸಲ್ಲಿಸಿದ್ದೆ. ಹಾಗೂ ನಟರಾಜ್ ಮತ್ತು ಅವರ ಕಾಂಟ್ರಾಕ್ಟ್ ನಂಬರ್ ಅನ್ನು ಪಡೆದು ಮನ್ಸೂರ್ ಖಾನ್ ಹೇಳಿದೆ. ಮನ್ಸೂರ್ ಖಾನ್ ಒಂದು ವಾಟ್ಸ್ಆಪ್ ನಂಬರ್ ಒಂದು ಚೀಲವನ್ನು ಒಬ್ಬ ವ್ಯಕ್ತಿ ಬಳಿ ನಾನು ಕಳಿಸಿದ್ದರು. ನಾನು ನಂಬರ್ ಕಾಲ್ ಮಾಡಿ ಒಬ್ಬ ವ್ಯಕ್ತಿಗೆ ಚೀಲವನ್ನು ಕೊಟ್ಟೆ. ಅದರಲ್ಲಿ 50 ಲಕ್ಷ ಇತ್ತು. ಮನ್ಸೂರ್ ಖಾನ್ ಬಂಗಾರದ ಒಡಗಳನ್ನು ಕರಗಿಸಿ ಅದನ್ನು ಮಾರಾಟ ಮಾಡಿ ಬಂದ ಜನರಿಗೆ ಕೊಡುತ್ತಿದ್ದ. ದೆನ್ ನಾನ್ ಲಿಟಲ್ ಬಿಲೋ ನಂತರ LC ನಾಗರಾಜ್ಗೆ 2 ಕೋಟಿ ರು ಕೊಡುವಂತೆ ಮನ್ಸೂರ್ ಖಾನ್ ತಿಳಿಸಿದ ಮೇರೆಗೆ ನಾನು ಹಣವನ್ನು ಮಂಜುನಾಥ್ ಎಂಬ ವ್ಯಕ್ತಿಗೆ ಕೊಟ್ಟೆ. ನಂತರ IMA ನೌಕರಾದ ವಸೀಂ ಮೂಲಕ 2 ಕೋಟಿ ಹಣವನ್ನು ಮಂಜುನಾಥ್ಗೆ ಕೊಡಲು ಕಳಿಸಿಕೊಟ್ಟು ಅದನ್ನು ನಾನು ಮಂಜುನಾಥ್ಗೆ ಕೊಟ್ಟೆ. Then one more 164 statement at page 106.
Every statement is there.
In every statement is there.
106.
106. Relevant, my lord will find at page 113. Interest pertaining to cashing of cash, so and so. Para A and B.
ಆಮೇಲೆ
Then my lord, further statement.
164 is 161.
ಎಲ್ಲ 164 ಇದೆಲ್ಲವು. All are 160. Then not page 125, Wasim. ಅದ್ರಲ್ಲಿ ವಸೀಂ ಬ್ರೋ ಅಂತ ಯಾವುದೋ ಒಂದು ಹೆಸರಿತ್ತು.
ವಸೀಂ ಬ್ರೋ.
Wasim bro. Then what is relevant at page 128. It starts from 125. Relevant at page 128. One paragraph, man.
During 2018.
During 2000, after about 6 lines, once on the instructions of Mansoor Khan, I had received cash back containing 1 crore from Mansoor Khan. I delivered the same to Sri so-and-so on his residence at Jayanagar 7 block. On 28/11/2018. No, he is one of the co-accused. I have delivered 50 lakhs to Nazimuddin on instructions of Mansoor Khan and later came to know that his amount was delivered to LC Nagaraj. Then the last statement, Wasim, what is page 130, not at page 138. Fifth line from the top. Mansoor Khan ಹೇಳಿದ ಹಾಗೆ IMA ಆಫೀಸಿನಿಂದ ರು 50 ಲಕ್ಷ ನಗದನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಿಕೊಂಡು ನಿಜಾಮುದ್ದೀನ್ಗೆ ಕೊಟ್ಟಿದ್ದ. ಅಲ್ಲ, ಮೇಲಿಂದ 5ನೇ ಲೈನ್ಸ್. Page 138.
ಮನ್ಸೂರ್ ಖಾನ್
ಹೇಳಿದ ಹಾಗೆ IMA ಆಫೀಸಿನಿಂದ ರು 50 ಲಕ್ಷ ನಗದನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಿಕೊಂಡು ನಿಜಾಮುದ್ದೀನ್ಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ನಂತರ ನಿಜಾಮುದ್ದೀನ್ ರು 50 ಲಕ್ಷ ಹಣವನ್ನು LC ನಾಗರಾಜ್ಗೆ ಕೊಟ್ಟಿರುವುದಾಗಿ ತಿಳಿಸಿದರು. Sir, all the 164 statement coupled with the entries in the cash flow statement which were entered at an undisputed point in time. Sir, later will not download.
ಇಲ್ಲಿ ಫ್ಲಾಕ್ಸ್ ಕಾಣ್ತಾ ಇದೆಯಲ್ಲ, ಅದೆಲ್ಲ ನಿಮ್ದೆ.
ಅದೆಲ್ಲ ನಂದಲ್ಲ. ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ನಾನು ಇನ್ನೊಬ್ರು ಕೊಟ್ಟೆ LC ನಾಗರಾಜ್ ಕೊಡಕ್ಕೆ ಅಂತ. Never that. Just have a look at.
Now come to those statements.
Yes. Would you like to come to page number 92? That was one of the statements that are.
No, we'll go one by one.
Yes.
Come to
First of all, at page.
first bank account ಬನ್ನಿ.
Yes. ಇದು ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಯಾರಿಗೂ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರೋದು ಅಂತ.
ಅಲ್ಲ, ನಿಮಗೆ ಬಂದಿಲ್ವಾ ದುಡ್ಡು?
ಇಲ್ಲ, ಬ್ಯಾಂಕ್ ಇನ್ ಮೈ ನೇಮ್ ದಟ್ ಇಸ್ ದ ಎಕ್ಸ್ಪೆನ್ಸ್ ಇನ್ಕರ್ಡ್ ಬೈ ದೆಮ್ ಅಂತ ಹೇಳಕ್ಕೆ ಅವ್ರ ಸ್ಟೇಟ್ ಇಸ್ ಅಲೀಜ್ಡ್. Now, would your lordship have a look at page number 84?
84.
Yes. This is the 164 statement, my lord, that was read out.
Yes.
May I point out what is common in all these 164 statements are all these statements are now made after the charge sheet is filed. This is
After the charge sheet is filed?
No, they are all approvers.
all
Approvers.
these persons are approvers. And it is their statement, my lord, after the charge sheet is filed. After they have turned.
Approver statement.
There are approval statement, not when we downloaded. Entries, not from the iCloud.
That's the first of the statement is at page 84. It starts.
Wasim bro is an approver.
Please. Nizamuddin, which is reading.
All right.
All these statements, my lord, would connect to Nizamuddin. 50 lakhs was handed over to Nizamuddin to be paid to me. Please have a look at page 92, the statement of Nizamuddin.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಪೇಜ್ 89 ಅಲ್ಲಿ he himself has handed over. ಅದು ಓದ್ದೆ ನಾನು.
Third paragraph. Mansoor wanted to settle the matter with LC Nagaraj Assistant Commissioner and paid 5.5 crores in 18 and 19 January. The amount was delivered by me in front of CCD Sadashiv. Initially, I delivered rupees 50 lakhs in front of DC Office Revenue, rupees 2 crore at CCD, 2 crores. It was paid to his assistant Manjunath village accountant as instructed by Mansoor. Manjunath gave clearance letter signed by M. Nagaraj. Therefore, my lord, it is never their allegation, my lord, it was paid to me. Their allegation is it is paid to Manjunath. And now, my lord, Manjunath's statement does not say. Would your lordship kindly, that is also, I have filed it along with my writ petition, my lord. That would say, Manjunath also tells that he never handed over to me.
He kept it for himself?
No, my lord, he has handed over to one person by name Chandru. That is the statement of.
Who is this Chandru?
Nobody knows. He is not an accused. He is not a witness in the charge sheet. And these are, my lords, the admitted statements available only in the charge sheet. I am not, my lord, looking into any material other than
So
what is produced. by
no
the
other
prosecution.
statement was available prior to the filing of the charge sheet?
No.
All have turned, statements are all an approver
Not
statement.
so far as Milord, payment of money is concerned, they're all based on the approval statement and Milord, what is downloaded from the iCloud, the entries for Milord dates back to the date on which amounts are paid.
But in so far as the letter that I have written, my lord, closing the case, I would make a specific reference to the order of withdrawal and make a statement, my lord, saying that this power is withdrawn to me. This is the letter written by the DG and IGP as well as the DCP West and the Deputy Commissioner. And my statement is, I am awaiting further instructions and forwarding this to the government for approval. I am closing it at my case level. That is all that I would say.
Asha?
Page 89 ಅಲ್ಲಿ Milord, just
don't
only
worry,
page 89.
Yes.
But para 2, last 5 lines, Milord. Suddenly Wasim brought one bag containing 50 lakhs rupees and Mansoor Khan gave one WhatsApp number.
Came back.
To hand over that money to LC Nagaraj in person. Accordingly, I have handed over the bag and came back.
It was for 2 months.
In person. Accordingly, I have handed over. Matter was closed off.
Bag illa, duddu illa, ಏನು?
If I hold it to be approvers on that ground, everybody will be left off the hook. Will pass orders.
Please.
Heard reserved. The transaction of business rules early.
Adali, please, that's all.
Yes.
Great.
Next.
Admission 17.
At 17, my lords, I appear for the respondent. I'll only pray for.
Well, Sarthi.
I'll file my objections in this case, my lords. Need to file.
Court ಗೆ ಬರಲ್ಲ ಅಂತಾರ ಅವರು.
Objections file ಮಾಡ್ತೇನೆ ಸ್ವಾಮಿ.
ಗೊತ್ತು. This is a Dharwad matter.
ಹೌದು ಧಾರವಾಡ.
2 weeks time ಕೊಟ್ರೆ I'll file my objections.
bail refuse
Yes, yes.
Then that was confirmed. Again, quashing ಹಾಕಿದ್ರು. That was
withdrawn.
withdrawn.
ಅವತ್ತು ಅಲ್ಲೇ ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡಿ ಬೇಲ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೆ ನಾನು.
Now, the simple ground raised is bail is granted without complying with section 15A.
So I'll
You are
file
not
my-
notified?
No.
My lords, interim bail has been granted. Regular bail, my lord, they have been served with a notice. They have come on record. They have
ಇಂಟರಿಮ್ ಬೇಲ್ ಯಾವಾಗಿಂದ ಇದೆ?
Anticipatory bail 438 ಅಲ್ಲಿ ಕೊಟ್ಟರು.
ಅಲ್ಲ ಆಯ್ತು, ಇಂಟರಿಮ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್.
Pending, please, my lord, the notice they have, it was given, sent to them.
If that is their contest, ಅದನ್ನ ಮಾಡಿ ರೆಗ್ಯುಲರ್ ಬೇಲ್.
This order has to go.
I'll
can't be
file my
granted
objections
without
to this matter.
That is.
Yeah,
like-
this has been languishing
No,
since
sorry.
2023, sir.
I'm sorry.
We're
please,
not
Lord.
filing objections.
I'll
not going to,
1 week
this
I'll
is
file.
1 year ಆಯ್ತು ಇದ್ರಲ್ಲೇನಿದೆ objection?
I'll
notify ಆಗಿತ್ತೋ ಇಲ್ಲ 15 comply
I'll
ಆಗಿದೆಯೋ
go through this whole thing, Lords. In
NDCT
1 week I
The
will,
order that is passed on the face of it is wrong.
I will argue, please, my lords, in 1 week's time.
Argue. Yes.
I'm not
Yes, sir,
prepared in
ನೀವು
this
ಹೇಳಿ.
matter, please, my lords.
May I please?
Lords, the senior was engaged in this, Lords, he's slightly inconvenienced
No
today.
problem, sir. Tell
I
me.
will argue it.
Last
Lords.
3 weeks this is happening.
Let's Tuesday ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ argument, but
Tuesday ಆಗಲ್ಲ.
ನಾಳೆ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ.
ನಾಳೆ
Tomorrow I will.
ಇಲ್ಲ sir. Yes.
Tomorrow I will, morning, first matter I will argue. my lord.
ಅದೇ
I'm not-
first matter.
I'm not prepared in this. I'll argue tomorrow. my lord. First thing, one opportunity, tomorrow I'll argue.
ನಾಳೆ ತಗೊಳ್ಳಿ.
I apologize, my lords, senior counsel also.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಅವರು ಆ ಕೇಸ್ಗೂ ಇದ್ದಾರೆ. Don't.
It has to be connected with the 482 man.
Huh?
482 also pending.
ಏನ್ ಹಾಕಿದ್ದಾರೆ?
They have filed for quashing.
26th will Lordship has directed me to take notice. And I said that party is not, ಅವ್ರಿಗೆ notice.
ಅಲ್ಲ 482 ಹಾಕಿಲ್ವಾ ಇದು?
ಹಾಕಿದ್ದಾರೆ ಅದನ್ನು
ಹಾಕಿದ್ದಾರೆ.
the lordship come before your lordship.
Lordship is posted back.
Which one?
They have filed a 482. The discharge they have filed has been rejected. Against that they filed a 482.
ಎರಡು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳೋಣ ಹಾಗಾದ್ರೆ. ಅವತ್ ಮತ್ತೆ ಅದರ ರೆಡಿ
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಒಂದೇ ಮಾರ್ನಿಂಗ್ ಐ ಗಾಟ್ ದ ಫೈಲ್, ಐ ಆರ್ಗ್ಯೂ ಇಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್. ಸಾರಿ.
ಮತ್ತೆ ತಗೊಳ್ಳೋಣ. Yes. It's he's already set on liberty. To withdraw it, there should be a strong ground. We'll see. Yes. Lest this matter heard the learned senior counsel, Professor Ravi Kumar appearing for the petitioner and KB Monish Kumar. The learned counsel for the respondent seeks time, yet again to go through the papers and make his submissions. List the matter on 26th. The counsel for the petitioner would submit that another petition is filed by the respondent seeking quashment of the entire proceedings. In criminal petition,
888-2, please, my lords, of 2024.
888-2 of 2024. Tag this petition along with 888-2. List them both on
26-9.
On 26th in the fresh matters list. Yes.
Right.
That is not last petition.
ಸುಮ್ನೆ ಹೇಳ್ದೆ sir.
Sorry, my lords, about today. my lords.
That the reasoning of the cabinet is not right, it is manifestly irrational. And it is not irrationality, manifestly irrational.
A little higher pedestal of
I'm very grateful.
Like how it is arbitrariness and manifest arbiter.
So, Malas, I'm very grateful, in fact, for the clarificatory question. The only case chosen by the Honorable Governor to cite is MP. But I've analyzed MP very carefully now, Malas. I will hate to say this, but possibly the governor has not been assisted sufficiently, he's not a lawyer, to analyze it equally carefully. MP does not go on bias, which answers my Lord's query, because in every case of a cabinet and every case of a governor, then MP must be read to mean it's a 6th category of discretionary power of governor. MP doesn't say so. Secondly, if my Lord's Wallace, the clarificatory question was correct in the conclusion, then there will be no manifest irrationality. Which governor needs to go to manifest irrationality, Wallace? Doesn't need to. Your Lordship is not to waste your Lordship's time to go to manifest irrationality when
No,
it's
not
a
necessarily.
presumptive bias.
It was on. Where are you reading?
Oh, I'm very sorry.
Yes.
I'm very sorry. Para 1.
Oh,
My apologies. I thought your Lordship was.
yes, sir.
And it will be faster reading many parts of it because of quotations,
No
but there are
problem.
very important
Yes.
points. The nuances are important. That's the.
Yes.
So now the first para is not about Chief Minister, it's about the heightened scrutiny of the court required. That's what I'm on. At the very outset, most respectfully submitted that the present case calls for the Honorable Court's consideration of an action taken by the highest constitutional function of the state, by which the umbrella of statutory protection accorded and afforded to public servants has been lifted. In a case involving the elected Chief Minister of the state, paving the way for an inquiry or investigation, as such shorn of personalities involved and the positions which they may presently hold today, this court must subject such action. This is the proposition. This court must subject such action to the necessary judicial scrutiny, such that the fine threads of constitutional democracy are kept in balance, are not frayed by unduly stretched or torn asunder. Little rhetorical, but this is just a setting. Little rhetorical. I'm not otherwise trying to. The following points are highlighted.
Torn apart. Yes. Asunder is apart. Yes.
Correct. Absolutely. The order of granting approval must fully disclose a reasoned application of mind by the authority concerned. In the instant case, the impugned order of the governor fails to meet this test, the fact there exists this power, albeit an extremely narrow one. Now, this is the nuance. It exists. Nobody is denying. My learned friends have argued as if it's an automatic. You just call out two names: cabinet, governor, chief minister. New discretionary power. No. No. Narrow one. To differ with the aid and advice in certain situations, I will be demonstrating this, does not exempt or relieve the governor from the obligation of passing a reasoned order disclosing application of mind. Because they are doing a double whammy. Just note this. Actually, in the normal course, the governor is a no-go area. You are allowing a special area to the governor in a matter where also additionally having taken that power, he's not disclosing his mind. I will call it, Malos, in loose colloquialism, double whammy. The governor anyway can't enter this house. In the case of a chief minister, a nuanced, limited case, he may enter the house. But having entered the house in an exceptional area, he also gives no reasons. It's a double whammy. It's a double constitutional whammy. The reliance by respondent to on file notings and comparative charts, tables or notes analysis as dictated by the governor. Well, I take it when we say dictated by the governor, no governor dictates what your lordship saw. We all accept it. We can say dictated by governor's office, no problem. Don't say dictated by the governor. I don't think anybody here is so gullible to think the governor has the time or what is the interest to dictate what your lordship saw in the files. So let's call it governor's office. Is wholly impermissible. We live in the real world, Manoj. We have to smell the coffee. We can't be in some other land. Is wholly impermissible in the absence of these documents being placed on record under cover of an affidavit. That also I let go. Manoj. The affidavit is not put. Let's leave that. It's a point to be noted nevertheless. Moreover, in any event, the impugned order itself refers only to allegations in the petitions and the supporting documents and makes no reference to these charts, tables, notes, analysis in the order. No reference, Malas. Not one word. Not a word. I've checked it, Malas. And therefore, it is not an order which refers to or is based on antecedent file notings, nor does it endorse, accept, adopt, or in any way engraft such notings. All those 4 words. Endorse, accept, adopt, or engraft. Malas, if this principle is accepted, which judicial review can your lordship squash? I am putting the same kind of question in different way. Which lordship will never have a case. The file speaks for itself. I have written an order, matter dismissed. Please check up the file and find the reasons. I have a very impressive staff. I have thousands of pages. I have people making notes. I have dismissed your matter. Check up the reasons from the file. That's not the law, Malas. The whole administrative law, public law will fall to the ground. Your lordship's doctor of judicial review, forget Tata Cellular, Malas. Ordinary principles of judicial review will not be there. The nature and extent of judicial review as it applies to such actions of the governor, applying his independent discretion. Now, Malas, here you are more. Your lordship knows you are going to exceptional area. Therefore, judicial review is more. Therefore, reasoning has to be more robust. The other nuances which have been missed out, with great respect, I say so, Malas, in the respondent's approach, must be all the more robust in cases where the governor is exercising a power that ought ordinarily to be exercised only on the aid and advice of the Council of Ministers. Thus, in cases where a different view is taken, the burden is higher to show that there was manifest irrationality. This is a phrase of Malas MP. In the advice of the Council of Ministers, thus requiring the matter to be considered decided independently.
So whenever the cabinet he is disagreeing with the cabinet, the reason should be on a higher pedestal.
A, starting point is that. B, your lordship's scrutiny also is correspondingly more heightened on those reasons.
Yes.
It's not, nobody is final, only your lordship's final, that too on subject to Supreme Court.
Yes.
In fact, the Supreme Court joke is the Supreme Court is right because it is final. It is not final because it is right. Nobody is final except God, Malas.
Yes,
But in our hierarchy, the governor is not final.
No, we are reviewing it now. Yes.
So, Malas, these two double heightened is important. Malas, you are going to an exceptional area. The Malas, very nice, those debates are worth going every time back. When I read those debates, Malas, Mr. Ambedkar, there's a huge long debate about governors, Malas. He says, why should you not have elected governors? Very strong, genuine proposal, bona fide. Then there's another debate about, Malas, how will you find good people? So he says, Mr. Ambedkar replies, he says, there cannot be 2 swords in 1 scabbard. Ek म्यान में 2 तलवार नहीं.
That's why Article 143 of the debates was reduced to 163.
163, no, and then he says in the debates, he says there can't be 2 swords in 1 scabbard. Then he says that we are in fact thinking, it's a very interesting passage, we are thinking of nominating governors and the post is so kind of non-active that we are very doubtful that we'll get any applicants for the job. That's not true today, Manas. But Ambedkar certainly thought that, Manas. Anyway, the idea of a governor was a no-go area in 95%.
No, if
Now,
you see the Constituent Assembly debates,
Yes,
where
yes.
it was, the draft
Yes.
was drawn first. Article 143 dealt with this. where
Yes.
Governor has to be elected, nominated or otherwise.
Exactly.
Then 163 is the final form that has come.
In between
Props.
is this discussion, he said, no, elected means he's also elected chief minister. I am also elected governor, 2 spots in 1 scabbard.
That's why it
You
was
want to
not.
neutralize him and put him only below the nominated. Then he says nominated also with very little powers. Nobody may want the job at all. Then below the next point. The power of granting approval under 17A of the POCA is not an independent discretionary power of the governor, but an executive power or executive function which should ordinarily and normally be exercised by the governor only on the aid and advice. This is consistent with both some last sentence in my proposition, wrongly suggested to your lordship otherwise. A broad brush is done. It is thrown, some share at this, on that one word, not exhaustive. Lordship remembers the argument. It's totally wrong. Exhaustive doesn't mean Lordship is rewriting the constitution with a number of new engraftment of the governor's power. The exceptions to this rule are not an open-ended category, nor did the Honorable Supreme Court in some shades set forth a non-exhaustive list as sought to be contended. Now, real para is, this is IR 154. And there is nothing in the majority which is inconsistent with 154. Nothing. As part of the concurring judgment, there is no variance by the majority to this concurrence. I'll be developing all this, but it's just a summary. The decision is MP Oil carves out a narrow MP Special Police, I'm very sorry, narrow and extremely limited exception where the governor may differ from the aid and advice. Now just see the nuance. Where there is overwhelming material on record on the basis of which prima facie case is clearly made out, and yet the council has refused sanction. I'm taking Wallace. Forget this case, I'm giving the law Wallace. Then to the extent the decision of the council is ex facie or manifestly irrational. Manifestly means ex facie actually. Or relevant material has not been considered, the governor may take a different view. That's the nuance. The findings in para 32 of the judgment, which are cited in the impugned order, relate to manifest irrationality and not to apparent bias. Now look at the error now. This is a matter of watched. I don't want to oversimplify, I don't want to exaggerate. Just kindly consider this. The governor, the Honorable Governor cites one para of MP, which is 32. And then entire 5 pages is bias, presumptive. The clarificatory question which my lord put. Presumptive bias, automatic bias. And he cites this one para. There is a manifest error by the governor himself because the para cited does not touch on bias. It says apparent bias, which means demonstrated bias. Somewhere, he's attending the meeting. Demonstration is not difficult. I attend the meeting. Or I don't attend the meeting, I attend the meeting and I say, I will go out to the room and have a cup of coffee, you go and decide. Or I recuse, this meeting is separate, and otherwise the man is fully in every ministry dealing with the subject. It's possible. It happened partly in Antule's case, where I had the privilege of assisting the court. Antule, your lordship sees the file notice that directly is involved in so many things.
Yes.
So now in that case, apparent bias may be demonstrable bias. But if subconscious bias was the test alone, then your lordship doesn't have to go to manifest irrationality. And the moment you have a paradigm of a cabinet, a chief minister and a governor, it's automatic.
No, the two are contradictory. Subconscious, any concept of subconsciousness need not be manifest at all. It's in the subconscious level.
Yeah, no, I'm saying subconscious will mean manifest is to create the reasons. Manifest is not create bias. Manifest is irrationality in the order. I'm saying, if your lordship were to accept presumptive automatic bias, then the law would be that in any case and every case, without examining the reasons of the cabinet for being wrong or right, merely because it is the cabinet and merely because it is the CM, the governor must automatically deny or grant sanction, as the case may be, on the ground that MP means that the moment there are three entities, governor, CM and cabinet, bias is established. I don't have to examine the order of the cabinet to see whether it is manifest irrational. I hope I'm clear. That's my proposition. So that's the proposition.
So you're saying that irrationality should be palpable and demonstrable.
In the order, no.
In the order, only then
Ah.
that would come about. Is,
Or
that is your
demonstrable means,
suggestion?
fellas, he must address it. I will let it put it lower. Let me put it lower for, my lord is absolutely right according to me in the way your lordship has formulated it. So that is number one. But let us take a worse case against me. I am now deliberately testing. First point is what your lordship has said. That's the perfect formulation for manifest irrationality. But now I'm taking a point against myself. Let me assume that the governor doesn't delve into the way your lordship has put it just now. He must show something that, look, I have read para 50 to 80 of this cabinet decision. They missed out that in para 69, this gentleman was actually handling the portfolio, or he gave an instruction, or he did sign the file. This is the error of the cabinet. And therefore, I believe prima facie there should be some inquiry. What the learned governor does is, he doesn't address, he doesn't go down that path at all. He says only, I'll read the order again,
Yes.
He says, because this is a cabinet, cabinet is deemed to be, I wish chief ministers would appoint cabinet the way the governor thinks they can. A lot of chief ministers would be very well wistful to be told that every member of the cabinet is appointed by them. Your lordship knows that, all of us know it. But let us for a minute assume the only reason given is cabinet is deemed to be part of Mr. Siddaramaiah. Siddaramaiah is the head, and the constitution says that the cabinet is represented through the chief minister. He's the first among equals. Therefore, presumptive bias, what your lordship put to me in a question form. Therefore, there is no question of my going and seeing where in para 89 they have messed up or given an irrational reason. I don't need to go there. Why? Because para 32 of MP Oil says so. But MP Oil never talks of bias. I'll read that. MP Oil goes into and says the cabinet is wrong for these reasons. And therefore, the governor must do it independently and decide it like this. This is the error of the approach. Para 2.3.4.
No, are you saying that the governor should not have disagreed with the cabinet?
Not at all. I will
So
never say
his
that.
disagreement should have been found in the order.
In his order,
Reasons in the
in
order.
the governor's order.
Governor's order. That
Absolutely.
is your submission.
That is right. I can never say that he can never disagree. That is an extreme proposition, and that will never be said.
So the disagreement should be found by
A-
reasons recorded in writing in the
First
order.
part is just your lordship, full stop on the first sentence. Disagreement must be found in the order. That is enough, full stop.
All right. Yes.
Second part of my lord's formulation. If it is found in the order must demonstrate manifest irrationality in the cabinet with which he is disagreeing.
Why should it be found in the order only if the files contain reasons?
He has to, no, files will contain, he has to, not by, he has to give some process of reasoning by which he comes to that conclusion.
Yes.
The third part, if the second part is not correct, then the order will say, I grant sanction, go and find the reasons in the file. Then what is your lordship going to do? Judicial review? What is the heightened judicial review? What is the meaning of manifest irrationality of MP? Your lordship will have then the Sphinx. Then the Sphinx comes in. Your lordship has to dig behind the Sphinx and find out something.
Yes.
Last one. MP police is not an authority for the proposition that there is any presumptive rule of apparent bias. I'm addressing the issue. Your lordship's clarificatory question is more pointed, but in a sense I've addressed it here, partly, without your
No,
lordship.
I am just getting clarification what is running in my mind. So you should
No,
not.
I am very grateful. I am genuinely grateful.
I'm not disturbing your flow.
But
but
I am
yes.
genuinely, I would not say it otherwise.
Yes.
I'm genuine because it helps us to clarify as we go along. Any query, it's most welcome, but it genuinely helps me to clarify because this is a matter where we are in the frontiers to some extent. Lordship should get the law right, apply to the facts secondly.
Because the submissions are so much, the horizons are so wide now. I need to take some clarification somewhere.
Great respect,
yes.
it's most welcome and I'm absolutely grateful. The proposition that there is any presumptive rule of apparent bias on the basis of which the governor must always independently consider the matter when an allegation relates. I am denying that is so. The first sentence. Paragraph 2.3.4, page 5.
Yes, I am there.
The question of apparent bias did not arise in that case. Rather, that case concerned a question of likelihood of bias, also expressly rejected by the Supreme Court at So, subconscious bias is out. Your Worship, no, subconscious is not likelihood. Likelihood means I must show that there is some facts which will show bias against him. So that was the case. Even that was rejected. But still the matter went the other way. Why? Because of irrationality. That's what is developing now. The reliance on para 17 in the written submissions is misplaced and misleading. The MP Special Police Establishment case is not and should not be read as general authority for the proposition that in every case where there is an allegation against the Chief Minister, the governor can exercise discretion independently, even absent any irrationality in aid and advice given by the cabinet. The mere fact that the governor may, in certain very limited situations, differ from the aid and advice of the Council of Ministers does not imply that every such different view of the governor is to be automatically preferred. Just like every view of the cabinet need not be preferred. My lord is absolutely right in that query, but I'm not suggesting that. In fact, the ability of the governor to decide to differ, this is very important with that boldface. The ability of the governor to differ is itself necessarily linked to a showing of manifest irrationality of the advice received. And that makes sense, fellows. Your Lordship has a proper governance up to the judicial system then. Somebody gives an advice, don't prosecute him. That is not final, fellows. It can be rotten, can be horrible. Somebody here gives an advice that I agree with that advice. He can be equally horrible, he can be good. And your Lordship is the ultimate master, ultimate meaning in the judicial hierarchy. How does your Lordship do your job, Malas, if these two people don't give anything and they say, we just decide? And the test your Lordship applies will always be of irrationality. Has to be, Malas. There is no basis to suggest in the present case, either reflected in the governor's input or otherwise, that the decision was in any way irrational. Forget your Lordship reviewing, there is no such reason given by the governor. Even the written submissions on behalf of R2 do not canvass irrationality at all. They get stuck, fellows, by misreading 32, the other side, in the submission, and they just quote MP because the governor quoted it, not realizing that the governor never went on bias, fellows, in that case. Rather, the submission is entirely based on apparent bias, assuming it to be a presumptive rule that where there is an allegation against the Chief Minister or member of council, the council is automatically disentitled or disabled. This is exactly the query I think now, Malas, it fits in, which your Lordship put to me. It's exactly that issue. The council is automatically disentitled. The word automatically is important for me, my Lordship, underline automatically. Disentitled or disabled from divested from exercising its powers. These powers are instead vested as discretionary powers. The decision of the Supreme Court and MP does not mandate any such presumptive rule, nor ought such a blanket rule to apply where executive powers vested in the state by statute are transposed as discretionary powers of the governor merely because the allegations relate to a chief minister or member of council of ministers. The reference to the file put up to the governor and comparative charts, as well as notes dictated by the governor as part of a decision-making process, do not suggest any reasons as to why the advice was manifestly irrational. An optical juxtaposition of two versions in a comparative table cannot be equated with an application of mind. As your Lordship said, well, I could have made 3 columns. Also, I could have made 4 columns. Why does the Lordship prefer that column to this column, to this column, to this column? Let there be 5 paragraphs, 3 paragraphs, 2 paragraphs. Why that is preferred and this is not preferred, this is preferred, this is not preferred. I can't make a table and give a Lordship. These are the various versions. The process of ratiocination required a link, a chain, or a clear nexus between these materials, the reasoning, if any, of the impugned order, and the conclusion there is. All this is conspicuous by its absence. The impugned order of the governor was passed in undue haste, with a predetermined mind, and exhibits a cherry picking. This word cherry picking is very important. I'll just show in a minute. But this is a case which demonstrates without doubt there is cherry picking. Without doubt. And very interesting. It shows cherry picking in the wrong and it shows cherry picking in the right. I'll just show that in a minute. Very interesting case. Where the present case was unduly and hastily fast-tracked, while several other applications for prior approval remained pending for long duration. My lord knows those 6 examples I gave. One year, Manoj. One example is 2 years. 2 years. 2 years. Interestingly,
Still
while your
pen-
lordship is hearing that matter,
Still pending?
no, while your lordship is hearing the matter, perhaps somebody's arguments have had some effect. One of those 2-year applications has been decided on 8th of August. And that is the cherry picking I'm going to show in a minute. After your lordships have heard most things just now. And it's very interesting. It's very instructive as what the governor could do, should not do, and did do. That is one of the complaint of which month in 21? 2021, which month? It's in 21. Decided in 24. Mine is taken up the same day and show cause is issued. Well, nobody's going to come and say this Article 14 arbitrary written on the file. Your lordship, read between the
No.
lines.
That was sanction or approval?
That was approval.
17A.
Your lordship would not even find a 17A pending for 17 months. Here we are 3 years. Give me the date of that application.
But in other cases, sanction was sought.
No, is it sanction or 17?
I don't want to be wrong. I'm told it is.
19th.
Give me the date. I am instructed.
No, it can't be 17A, I guess.
But it should not be, is different from can't be, Malus. It is. It is.
17.
You sure?
Page 127. Do you want me to give you?
120, give it. 127, we have the order. Let's be factually correct. Give it. This is issued while your lordship is hearing the matter. So.
Not while hearing the matter, but
One minute.
You appear for the complainant,
All
not the
right.
governor.
No. What is this?
After the PM's reply, this particular document, just come to 127 minutes. After this, the chief minister, my client, replied. When did I reply? 3rd of August, I replied. 9th of August, this order comes. As directed, I am enclosing a copy of the decision of the competent authority for permission to conduct inquiry under 17A. So first point is 17A. I hope I'm clear, Malas. It is 17A. Against Shishikala Jole, former government, etc., etc.
It is, permission is denied.
Yes. That part is not surprising, Malas, but that is different. This is denied. It is. Now, let's not get into details, but this is a supposed sting operation on camera for a person supposedly supplying eggs, etc. for midday meals of schools, recorded on candid camera, where the Honorable Governor takes 2.5 years to apply his mind, and after 2.5 years or 3 years, rejects it. In my case, for 20 years, not a single file dealt with by me, and he issues show cause on the same day. Well, this is not Article 14, it's shocking, is the word for it. But at the moment, I'll be coming to this thing. 17A is important, the question my lords asked. Give me the date when the application. I'll not give you the date. It's 2021 someday. 9/12/2021. And the decision is 9th August 2024, exactly 3 years. 4 months less. That's all right. You don't get into details. Malus, the application is also in this bunch at page 693. In the writ petition, Annexure J, is this application which I talked about. December 2021 is when the application was made to prosecute or to get this 17A. Yes. This small digression, I'll spending half a minute on Article 14, Malus, as I've said so many times, the 2 most important articles, and Malus even more than 21 is 14. And 14 had 3 phases, Malus. Give me a minute to digress. I know it's a digression, but it's very important, Malus, to emphasize. Till Malus, when it came in, your lordship knows those so many decisions, Charanjit and R.K. Dalmia, we had basically the discrimination facet of 14. Classification, doctrine and discrimination, but classification mainly. In Royappa, which came 30 years after 74, 30 years after independence. Justice Bhagwati, for the first time, brought in the seeds of arbitrariness. Then those 70s and 80s, the same Justice Bhagwati developed it beyond compare in all the Ramanna Shettis and all the cases. I hope I'm clear on this.
Yes, yes.
So you had a second facet of 14. Then, Maluz, the third facet came in Maneka, developed later, or procedural due process. We still kept the figment of the fig leaf of denying that we have no substantive due process in our constitution, because the Lordship knows Venegal Rao had gone abroad.
Yes.
Frankfurter had said, do anything, but for God's sake, don't put this phrase due process. So, Article 21 had a due process clause, or the counterpart article. So when Venegal Rao met Frankfurter, who was a very restrained, limited judicial review man, he said the bugbear of American jurisprudence is this crazy phrase, due process. Don't use it, do anything else you like. So Venegal Rao came back and reported. So they put this phrase, except in accordance with law, from the Japanese constitution. They dropped due process. So we like to say that we had no due process, but Maneka brought in procedural due process, clearly. So that was phase number 3. Then finally now, in a trinity of judgments authored by Justice Nariman, there is full substantive, full-blooded substantive due process. Both Venegal Rao and Frankfurter must turn over in their grave. Because triple talaq, this adultery, then that Swiss ribbons, all of them recognize IBC under different. That substantive due process is a part. So your Lordship can see the degree of unjustness to strike down. Now, I am saying that if your Lordship were to apply even the old test of 14, now we have 4 facets of 14. This kind of conduct that you take 3 years minus 4 months for a 17A and then reject it for a candid camera, the complaint is there, Wallace. It's a recording of what is done about midday meals. And on the same day, for a person who for 23 years has not signed a file, not made a recommendation, not been anywhere, you issue a show cause. Then, Wallace, you don't need Article 14 for that, you need common sense, is all that I'm saying. You don't need Article 14 to make out Wallace clearly. Now, Wallace, at 2.9. No, I'm sorry, 2.8 Wallace is very important. 2.8 your Lordship is marked cherry picking. Now your Lordship will come to 2.8A. Two facets are interesting and ironical in this regard. None of the diverse complainants seek any sanction, prior approval in respect of any of the multifarious public servants alleged to be involved in the present case, stretching from 98 to 21 over a period of 23 years. I'm sorry, my Lord has gotten very sorry. 2.8A. The last sentence, please read. Petitioner CM is singled out for the affection of the complainants. 23 years, hundreds of officers, not a single one. Secondly, in stark contrast to the impugned order, which does not contain a word as to how, what, when, and in which manner. This is very interesting for us. The governor finds the petitioner even remotely culpable for the purpose of granting sanction or prior approval. The very same governor gives specific reasons in the order of 8th of August regarding lack of culpability while rejecting the proposal of prior approval in the case of Sashikala Jole. A case specifically stated in the pleadings pending before the governor for several months. Well, the sentence is not correctly drafted. It should be comma, maybe continues. The point is, Wallace, I am not asking for reasons, inviting. I'm saying the order is bad because it has no reasons. But is it not relevant that your Lordship is hearing a matter? 8th August is hardly a month ago or whatever, Wallace. Your Lordship gets an order which has reasons copiously saying why don't grant sanction. Because this person is not prima facie complicit. Because this person is not prima facie found to be involved. And in my case, on the same day show cause, not a single reason. Then 2.9. The manner in which approval has been granted is contrary to the statutory scheme and judicial interpretation of 17A. The statutory restraint is on the investigating officer. It is thus the investigating officer to first form an opinion. That inquiry, this point is important, Wallace, in the nuance of the interpretation. I'm coming to that later. Thus, for the investigating officer to first form an opinion, don't prevent him from doing that by this lateral entry. That inquiry or investigation is warranted and then seek approval or inquire investigation. The statute does not contemplate the said approval being sought by a third party, namely the complainant. The respondent wrongly contends that the test to be applied at the stage of 17 capital A is only whether the materials disclose the commission of a cognizable offense. The legislative history behind the introduction of 17A does not support such a contention, as is demonstrated later, even assuming that 17A is different from the standard of sanction. I'm assuming it, my lord has got that para. That does not mean that it is a Lalita Kumari standard. Lordship may add in hand here. Third point, even Lalita Kumari is not met on the facts. That's a third level argument, fellows. Because the same reason, doesn't tell you how I'm involved, when I'm involved, what did I do, recommendation, signing, event, decision, minister, portfolio, nothing. Even if the Lalita Kumari test is applied, in the facts of this case, it is clear on record that do not disclose the commission. The complaint request for prior approval does not specifically advert to any recommendation made, decision taken, or even any action. This is the single most important point in this case in my respectful submission. It's obvious from the reading of the order. The complaint request for prior approval sanction proceeds on a series of surmises and conjectures, casting doubt on official actions taken in the ordinary course by different officials at different times under different administrations. They also proceed to disregard several registered deeds and instruments which ought by the nature not to be doubted. It is clear that the petitioner himself had no role to play in the decisions or even deliberations. I've added at the end a list of dates for lordships, which I'll be coming to. It's very, very important on the facts. All this prejudice was created. Oh, there's a writ suppressed from you. The order in one case is this, in your case is this. It was never denotified. It was never factually wrong. Documents of registered deeds are there. They argued all this. I'm only rebutting. They argued the facts copiously. The poor cabinet has gone into it. My writ petitioner has got the documents. Still they argued those facts. So I put a list of dates at the end, Malas. Only for prejudice. Only to prejudice your lordships. That look, all these years, there is no acquisition. The acquisition is valid. The acquisition could not have been given back. 48A is wrongly done. Notification is wrong. Everything is wrong. Document said otherwise. Now, Malas, this 50-50 rule. It is clear that the petitioner himself had no role to play, or even deliberations leading to the decisions in the case of denotification, registration of deeds, decision by Muda with regard to 50-50 rule being applied, and allotment of compensatory sites to wife of the petitioner. Otherwise, Malas, had I got a role to play, I would certainly not have taken at least a decade to get this done. And had I a role to play, some of the most operative decisions would not have been taken when I was in the opposition. Some of the major ones. In fact, the Muda decision was taken in 2020 and implemented in 21-22 at a time when the petitioner was in opposition and not even a part of the government. And Malas, this is given to 19 or 20 or whatever number of other people also. It's a general policy decision. Nothing to do with me.
But your son was a part of the board there in.
I'll be showing that board. That's part of my list.
By being an MLA.
MLA. He's ex officio.
Ex officio member of the decision-making body on that particular day. Your son was a part of it.
Which, Malas, is a ex officio requirement A, I did not make him. B, the decision is across the board for so many people.
No, true. It's across the board, but.
And I'll be dealing with that.
2 meetings.
And Malas, he is fortunately not named as
Two
an
meetings,
accused.
one in 2020 and one in 2021.
Yes. And Malas, they have not made him an accused. They have not short sanctioned.
They are not.
No, it's just I'm just saying these 2 or 3 facts, but they're in the list of dates. Now, let us come to the next point. Shamsher Singh is important. Don't brush it aside as the respondents have done. They've completely brushed aside. This remains the bedrock for the last 60 years. 7 judges. Bedrock on constitutional law. President, governor, both. There's a typo there, 1974, not IG 74. Typo there.
Yes, sir.
The president as well as the governor is the constitutional or formal head. The president as well as the governor exercises his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. Wherever the constitution requires the satisfaction of the president or the governor for the exercise by the president or the governor of any power or function, the satisfaction required by the constitution is not the personal satisfaction of the president or governor, but the satisfaction of the president or governor in the constitutional sense in the cabinet system of government. That is, satisfaction of his council of ministers on whose aid and advice the president or the governor generally exercises all his powers and duties. And Malas, the old saying, the elected people have a fundamental right, a duty, I would say, to do good. But they also have a right, not a fundamental right, to do bad and wrong. But it is their right to do wrong. It is my right to do wrong, and this population will set me right. It is not the governor's right to set me right, or the president's, is what Shamsher Singh's soul and spirit is. That's the meaning of elected democracy, or in a parliamentary system. It may not be in a presidential system the same way. Then, Malas, 54. The provisions of the Constitution expressly require the governor to exercise his powers are contained in articles to which to illustrate. Now, Malas, one article is given on the third line. Come to the boldface. The other articles which speak of the discretion, there are typos here. Typos have not been seen. Paras, what is that section? S2 and 18.3 of the 6th schedule. Then articles so and so. The discretion conferred on the governor means that at the constitutional head or formal head, the part. This is one of the Northeast. Those powers, your lordship has special powers there, Malas. Then Malas 55.
Yes.
This is the failure of constitutional machinery. In the context, Article 163, I don't know why, Malas, only the articles are wrongly typed. Everything else is correctly typed. The number is 163.
Article 163.
Somebody is
one C.
going with the uppercase and the lowercase is this
That's
problem.
not correctly typed. That's all.
It's 163 actually.
Yes.
Multiple, all of them are like.
163.2 it should be.
In article, in this context, 163.2 is explicable on the decision of the governor in his discretion shall be final and the validity shall not be called in question. Next, 2 lines later. In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The Constitution does not aim at providing a parallel administration in the state by allowing the governor to go against the advice of the council of ministers. In such matters where the governor is to exercise his discretion, I'm reading para 56, he must discharge his duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. For the foregoing reasons, we hold that president or governor acts in the aid and advice of the council of ministers, with the prime minister at the head in the case of the union, chief minister at the head in the case of the state, in all matters which vest in the executive, whether those functions are executive or legislative in character. Neither the president nor governor is to exercise executive functions personally. I try and summarize some things in page 12. Next page. In relation, I put them point formulas. In relation to functions that are vested in the executive, the governor shall act at the aid and advice of the council with the chief minister at his head. The governor shall not exercise executive functions personally. 48 and 57 paras. Where the Constitution provides that the governor shall act in his discretion, here the articles are correctly put, Malas. Even in these matters, the governor shall act in harmony with his council of ministers. These are, Malas, nuances which we tend to forget. It is not, Malas, very interesting nuance. This Shamsher Singh, 74, Malas, is saying that even where he has a separate power, he must act in harmony with me in that. Look at the whole delicate balance. You can't say automatically I receive the cabinet decision because the chief minister is involved, I'll defer. Thus, there is a constitutional restriction on the discretion which is not to be exercised as a personal function or as a function conferred on him, EO nominee. In very limited scenarios, such as under 356 is a classic case, and 200, the governor may act in his own discretion even against the advice of his council. In such cases, the governor is to exercise his duty to the best of his judgment. That's para 55 and 56. Now, the most important, Justice Krishna Iyer. Now, why it is misrepresented, Justice Krishna Iyer is right. Not a word in the majority. He's concurring. Not a word in the majority dilutes or overrules or goes against him. Then why should Lordship not read Krishna Iyer? Justice Krishna Iyer just brush aside, he's a concurrence. But concurrence is not a dissent, Malas. Please don't read the concurrence as a dissent. You can point out that this concurrence is violated by this part of the majority. That I can understand. Not a word. Ignore it because of the concurrence. And Justice Krishna Iyer spoke for himself, Justice Bhagwati. If the inner voice of the founding fathers may be any guide, para 113, it is proved beyond reasonable doubt that the president and for sure the governor enjoys nothing more and nothing less than the status of a constitutional head in a cabinet type government, a few exceptions and marginal reservations apart. Mark this word, a few exceptions and marginal reservations apart. Actually, the governor has more powers than the president.
Yes.
People tend to forget that. President is even more limited. Governor has little extra powers. For example, president has no 356 fellows.
Yes.
Our Pakistan president has a 356, which he has liberally excised 2 or 3 times. He dismisses the national government with us. We decided against having that in the president. We had it only for the governor. Nobody can dismiss the central government here with us. Of course, there is some qualitative difference between the position of the president and governor. The former, under 74, has no discretionary powers. The latter too has none, save in tiny strips. Look at the approach. Tiny strips covered by, please forgive me for the typos, but it's 163, someone's coming at 1C3. And all the others are given. These discretionary powers exist only where expressly spelled out, and even these are not left to the sweet will of the governor, but are remote controlled by the union ministry. This is very important. Well, the governor, when he acts independently, so-called, is independent of the state government. But the union government is answerable to parliament with a whole set of provisions. Lordship knows the 356 proclamation expires if parliament doesn't approve it within a certain time period. Again, a minimal area centering around reports to be dispatched may not, that's for 356, not 35C, may not in the nature be amenable to ministerial advice. Now come to page 14. Even where express conferment of power of functions is written into the article, such business has to be disposed of decisively by the ministry, answerable to the legislature, and through it vicariously to the people, thus vindicating our democracy instead of surrendering it to a single summit soul. These are the simplest language which Justice Krishna may have used. He's erring on the side of oversimplicity. But a single summit soul has a rhythmic alliteration, which exactly describes the reason to avoid the governor or the president. That single summit soul is the governor or the president, whose deification is incompatible with the basics of our political architecture. Lest national elections become but Dead Sea fruits, legislative organs become labels full of sound and fury, signifying nothing, and the Council of Ministers put in a quandary responsibility to the House of the People and submission to the personal decision of the head of state. A parliamentary-style republic like ours could not have conceptualized its self-liquidation by this process. On the contrary, democratic, etc. Well, sometimes I think that how times have changed. Well, it's today, even if you have a person like Krishna Iyer, he could never go onto the bench. Because we are into narrow confines. You can't be in public life, you can't be in law, you can't be on the bench.
No, he was in public life.
Actively, a minister.
Yeah.
Forget active life.
As a
minister, Wallace.
For 3 years.
And then became a judge.
Then became a judge of the Kerala.
Which is why he never made it to the top, but he was a senior judge. But nobody could raise a finger. That is the spirit of the times. Nobody could even suggest this. And one of my most cherished memories is that as a young student, I wrote an article in the Illustrated Weekly.
Oh, the then Illustrated
Weekly, a very famous magazine.
Yes,
about election law. I had been in some elections, seeing something. Elections, law and reality. So I was juxtaposing. So, but Justice Krishna had retired by then in the 80s.
Yes.
He wrote a very nice note handwritten to me, saying I read the article. He knew my father, so he took the trouble of writing a note to me personally. And he read the whole thing and he wrote something which overwhelming to have him. Then 152. Long arguments on the terminological niceties of the various provisions, divorced from the essentials of parliamentary perspective, will land us in Himalayan constitutional blunders. Similarly, expressions like is satisfied, opinion, as he thinks fit, if it appears to, have to be interpreted by superimposing the invisible but very real presence of the ministry over the head of state. Opinion of, in the view of, appears to be. We declare the law of this. This is 154, which was brushed aside by saying this is only a concurrence. So I've quoted it. Please tell me which part of the majority dilutes or violates 154 or tell the Lordship it is the overbreadth. Unless you do that, you can't just brush it aside. Supreme Court, 7 judges. In that way, Bomai could be Bomai Lordship at 9 judges with 4 or 5 judgments. Most for all concurrences.
Yes, concurring.
Your Lordship doesn't brush aside just like that. Very Karnataka flavor, Malas Bommai. Well, the most important change in 356 has been that Mr. Hegde, by the time Bommai was delivered, he was the petitioner originally.
Yes, yes.
By the time Bommai was delivered, the government had changed 2-3 times.
Yes.
He never got the fruits of his victory. Subsequent to 2000, there are only 7, 8, 10 Malas 356s. Because your Lordship's judicial review was not only the same as
So
Bommai,
that
very
flood-
swift,
that
very
flood
swift.
So many things.
No, your Lordship's judicial review was very swift. I've had the privilege of assisting the court in Uttarakhand, Karnataka,
Yes.
Maharashtra. Your Lordship decided within a few weeks, this way or that way. So 356 did not become a very valuable tool to dismiss government because your Lordship said reinstall him back. In all these cases, Uttarakhand, Karnataka, have the elections or have a floor test and all that. Bommai Malas took 3-4 years before the man lost several governments. So he got a Parik victory.
Yes, it
We
was
dec-
a Pyrrhic victory.
It was a Parik victory, Malas. Although he established law forever, Malas. We declare the law of this branch of our constitution to be that the president and governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon in accordance with the advice of their ministers, save in a few well-known exceptional situations. Without being dogmatic or exhaustive. This was read to your Lordship, so I'm reading it, Malas. Please see the totality. Is it a fair interpretation? To say that this means non-exhaustive, means each case by case your Lordship will keep adding to the governor's powers. That's not fair, Malas. It's against the constitutional scheme. Without being dogmatic or exhaustive, these situations relate to the choice of the Prime Minister, restricted through this choice by the paramount consideration it should come. But this word exhaustive here means something totally different. They are saying we are obviously not itemizing everything. It is not a license or an invitation for my lords to keep on, Malas, having adventurous additions, which is what they are suggesting. The dismissal of a government which has lost its majority in the House but refuses to quit. The dissolution of the House for an appeal to the country is necessitous. Although this area, the head of state should avoid getting involved in politics, must be advised by the Prime Minister, who will eventually take the responsibility. We do not examine in detail the constitutional proprieties in these predicaments except to utter the caution that even here the action must be compelled by the peril to democracy, and the appeal to the House or to the country must become blatantly obligatory. Now, my conclusion, Malas, on this part. As such, the declaration of law in 154, which forms part of a concurring judgment, must be seen in proper context. By no stretch of imagination can the judgment in Shamsher be seen as providing an open-ended, non-executive list of subjects. That's the crucial point, where the Honorable Governor may exercise, etc. But rather the court expressly said it is confined to a few well-known exceptional situations, which your Lordship may in a very calibrated, controlled manner, restrained manner, sometimes allow. Then, Malas, the last judgment is where happened recently, Malas, the Maharashtra thing. This is not about this or 10th schedule, but Malas, just 2 minutes. Very after.
Continue at 2:30.
I'll continue.
Yes.
2:30, Malas?
2:30. Yes.
Obliged. Deeply obliged.
Yes. ಇದು 3.
Sorry, I apologize for that.
Now,
you
if
see the
you-
Constituent Assembly debates,
Yes,
where
yes.
it was, the draft
Yes.
was drawn first. Article 143 dealt with this. where
Yes.
Governor has to be elected, nominated or otherwise.
Exactly.
Then 163 is the final form that has come.
In between
That's-
is this discussion, he said, no, elected means he's also elected chief minister. I am also elected governor, 2 spots in 1 scabbard.
That's why it
You
was
want to
not.
neutralize him and put him only below the nominated. Then he says nominated also with very little powers. Nobody may want the job at all. Then what is the next point? The power of granting approval under 17A of the POCA is not an independent discretionary power of the governor, but an executive power or executive function which should ordinarily and normally be exercised by the governor only on the aid and advice. This is consistent with both some last sentence in my proposition, wrongly suggested to your lordship otherwise. A broad brush is done. It is thrown, some share at this, on that one word, not exhaustive. Lordship remembers the argument. It's totally wrong. Exhaustive doesn't mean Lordship is rewriting the constitution with a number of new engraftment of the governor's power. The exceptions to this rule are not an open-ended category, nor did the Honorable Supreme Court in some shades set forth a non-exhaustive list as sought to be contended. Now, real para is, this is IR 154. And there is nothing in the majority which is inconsistent with 154. Nothing. As part of the concurring judgment, there is no variance by the majority to this concurrence. I'll be developing all this, but it's just a summary. The decision is MP Oil carves out a narrow MP Special Police, I'm very sorry, narrow and extremely limited exception where the governor may differ from the aid and advice. Now just see the nuance. Where there is overwhelming material on record on the basis of which prima facie case is clearly made out, and yet the council has refused sanction. I'm taking Wallace. Forget this case, I'm giving the law Wallace. Then to the extent the decision of the council is ex facie or manifestly irrational. Manifestly means ex facie actually. Or relevant material has not been considered, the governor may take a different view. That's the nuance. The findings in para 32 of the judgment, which are cited in the impugned order, relate to manifest irrationality and not to apparent bias. Now look at the error now. This is a matter of caution. I don't want to oversimplify, I don't want to exaggerate. Just kindly consider this. The governor, the Honorable Governor cites one para of MP, which is 32. And then entire 5 pages is bias, presumptive. The clarificatory question which my lord put. Presumptive bias, automatic bias. And he cites this one para. There is a manifest error by the governor himself because the para cited does not touch on bias. It says apparent bias, which means demonstrated bias. Somewhere, he's attending the meeting. Well, demonstration is not difficult. I attend the meeting. Or I don't attend the meeting. I attend the meeting and I say, I will go out to the room and have a cup of coffee, you go and decide. Or I recuse. This meeting is separate. And otherwise the man is fully in every ministry dealing with the subject. It's possible. It happened partly in Antule's case, where I had the privilege of assisting the court. Antule, your lordship sees the file notice that directly is involved in so many things.
Yes.
So now in that case, apparent bias may be demonstrable bias. But if subconscious bias was the test alone, then your lordship doesn't have to go to manifest irrationality. And the moment you have a paradigm of a cabinet, a chief minister and a governor, it's automatic.
No, the two are contradictory. Subconscious, any concept of subconsciousness need not be manifest at all. This is the subconscious level.
Yeah, no, I'm saying subconscious will mean manifest is to create the reasons. Manifest is not create bias. Manifest is create irrationality in the order. I'm saying, if your lordship were to accept presumptive automatic bias, then the law would be that in any case and every case, without examining the reasons of the cabinet for being wrong or right, merely because it is the cabinet and merely because it is the CM, the governor must automatically deny or grant sanction, as the case may be, on the ground that MP means that the moment there are 3 entities, governor, CM and cabinet, bias is established. I don't have to examine the order of the cabinet to see whether it is manifest irrational. I hope I'm clear. That's my proposition. So that's the proposition.
So you're saying that irrationality should be palpable and demonstrable.
In the order, no.
In the order, only then that would come about. Is,
or
that is your
reversible means,
suggestion?
fellas, he must address it. I will let it put it lower. Let me put it lower for, my lord is absolutely right according to me in the way your lordship has formulated it. So that is number one. But let us take a worst case against me. I am now deliberately testing. First point is what your lordship has said. That's the perfect formulation for manifest irrationality. But now I'm taking a point against myself. Let me assume that the governor doesn't delve into the way your lordship has put it just now. He must show something that, look, I have read para 50 to 80 of this cabinet decision. They missed out that in para 69, this gentleman was actually handling the portfolio, or he gave an instruction, or he did sign the file. This is the error of the cabinet. And therefore, I believe prima facie there should be some inquiry. What the learned governor does is, he doesn't address, he doesn't go down that path at all. He says only, I'll read the order again,
Yes.
he says, because this is a cabinet is deemed to be, I wish chief ministers would appoint cabinet the way the governor thinks they can. A lot of chief ministers would be very well wistful to be told that every member of the cabinet is appointed by them. Your lordship knows that, all of us know it. But let us for a minute assume the only reason given is cabinet is deemed to be part of Mr. Siddaramaiah. Siddaramaiah is the head, and the constitution says that the cabinet is represented through the chief minister. He's the first among equals. Therefore, presumptive bias, what your lordship put to me in a question form. Therefore, there is no question of my going and seeing where in para 89 they have messed up or given an irrational reason. I don't need to go there. Why? Because para 32 of MP Oil says so. But MP Oil never talks of bias. I'll read that. MP Oil goes into and says the cabinet is wrong for these reasons. And therefore, the governor must do it independently and decide it like this. This is the error of the approach. Para 2.3.4.
No, are you saying that the governor should not have disagreed with the cabinet?
Not at all. I will
So
never say
his
that.
disagreement should have been found in the order.
In his order,
Reasons in the
in
order.
the governor's order.
Governor's order. That
Absolutely.
is your submission.
That is right. I can never say that he can never disagree. That is an extreme proposition, and that will never be said.
So the disagreement should be found
And
by reasons recorded in writing in the
first
order.
part is just your lordship, full stop on the first sentence. Disagreement must be found in the order. That is enough, full stop.
All right. Yes.
Second part of my lord's formulation. If it is found in the order must demonstrate manifest irrationality in the cabinet with which he is disagreeing.
Why should it be found in the order only if the files contain reasons?
He has to, no, files will contain, he has to, not by, he has to give.
Settlement.
Victim is 17 years, 11 months.
20th.
20th.
And custody idara? Tomorrow. Custody will take it tomorrow. 17 years, 11 months, there should be some. I'll look into the judgment only and pass. Not to worry. Yes. Hard realities of life, sir. Yes, we'll see. Yes, next. At least tomorrow in the fresh matters next. Halima, madam.
The only accused number 7, he is number 7, he is the only one remaining. Lord.
Split up.
All other, yes, split up.
Split up.
Yes, he is
Ivattagalla. Naale.
losing job.
Naale.
Past, because of this, he is. Naale. But Naale, please, Naale matra ಮಾಡಿ. This is the third date.
You should be reasonable at least in your expression. Yes. Next.
Pledge.
10 present. Naale tomorrow. Plus tomorrow. Yes.
Serial number 11, I appeal for the respondent.
Respondent has to file objection. 11.
Serial number 11, I represent.
List on 25th, 24th, objections, if any, by the next date of hearing, interim order to continue. Next.
Not I appeal for the petitioner's counsel. This is a forest matter. The government was directed to obtain instructions in relation to annexure
I'll file my
B.
objections, my lord. It,
Lord, it will be
List
taken up tomorrow.
on 20th.
May I persuade the honorable court to have it tomorrow because the FIR is registered.
No problem, sir. List on 20th. Yes. I will, the other matters after the completion of that third list matter, I will take.
List 3.
I'll be withdrawn, don't. Yes, adella same order will pass. Yes, Shatabish, on his legs.
Written synopsis is well.
Hagadre,
Please.
Raghavan sir, ಹೇಳಿ, you make a note of it. Yes, sir.
My lord, I want to bring to your lordship notice, my lord,
Or mostly Raghunath, ಆಮೇಲೆ ಮಾಡಿ.
Please, let's.
a subsequent development that has taken place.
Subsequent development.
Yes, my lord. Subsequent to the last. My lord, on 31st of August 2024, the government, my lord, has passed an order placing an officer of the Muda under
My lord, I have objections. This cannot be put on record, my lord. In fact,
How is that relevant?
and we have withdrawn that also.
Sir,
My lord, if my learned.
if the officer of Muda is placed under suspension due to this, you tell me.
I will. That is
Otherwise,
exactly. Please give
large
me.
scale corruption
Yes, my
in
lord,
Muda.
answer is yes. Please give me a
That has been
minute.
withdrawn all.
Before I am able to complete it, if my learned friend interferes, what shall I do?
You know what?
Kodi, sir.
We have withdrawn that also, my lord. That cannot be relied upon. A
No, they
document.
have withdrawn that suspension.
Doesn't
Please,
matter, my lord. I am
a
relying upon
document.
it. My lord, if my learned friend will bear with me for a minute, I may be wrong, but I am entitled to be heard.
All right. Yes,
We are
sir.
entitled for a
My lord,
copy.
please look at page
Suspension
number.
order, government. Then.
My lord, please look at page
Placing
number.
the-
ಆಯ್ತು.
Where is the copy given to the other side?
My lord, we've given a copy, we've given a copy yesterday, my lords.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy was served last week.
Yes.
My lord,
Other
please
copies.
see page number, internal
lord,
page number
My lord,
3.
my one request.
Let me say what I want to say, then my learned friend can
Let
say
him
what he
finish,
wants
sir.
to say.
I don't want him
I
to
may
say.
be-
That's the
That
point.
this
I may
problem
be
is
wrong.
VC and this problem. ನೀವು
I
VC ಹೇಳ್ತಾ ಇರ್ತೀರಾ, ಇವ್ರು ಇಲ್ಲಿ ಹೇಳ್ತಾ ಇರ್ತಾರೆ. Yes.
ಇಲ್ಲ ನನಗೆ ಒಂದು ಅವಕಾಶ ಕೊಡಿ ಅಷ್ಟೇ. ನಾನು ಸರಿ
No,
ಹೇಳೋ
no,
ಸರಿ
he says it's already withdrawn.
No, my lord, there's a fact which is stated. I want to point out to your lordships that. I
The
am not
fact of
on
the error, my
suspension.
lord, which we have withdrawn. That's the point.
We have
My
objected.
lord, can I point it out?
Material on record. It has no bearing on the case. This cannot validate the government.
No, even otherwise, the submission of the Advocate General is, it is withdrawn. If it,
Yes, but
where is the withdrawal order?
my lord, I'm pointing out a particular fact which has been stated in this order.
No, in an order that is withdrawn, what can
Doesn't
you?
matter.
Put up-
The suspension might have been withdrawn, but the facts are there. Kindly look at that fact. My lord, I may be wrong. Look at it, my lord. Please look at it.
Let me see, sir.
My lord, please turn to
Your
page
lordship
number
may
3.
kindly go to page
My
12.
lord, 1 minute, my lord. My learned friend will
Page
kindly bear
12.
with me.
That's why you should be here, sir. VC ಇದ್ರೆ problem ಆಗುತ್ತೆ.
Supreme
Yes.
Court matter ಇರ್ಬೇಕು, my lord.
My lord, page number 3 ನೋಡಿ ಒಂದೇ ಒಂದು ನಿಮಿಷ.
Yes.
ಅಲ್ಲಿ ಬಾ ಅಂತ ಇದೆ. ಅಷ್ಟೇ ನಾವು ಓದೋದು, ಇನ್ನೇನು ಓದಲ್ಲ.
ಏನ್ ಯಾರು ಕರೀತಾ ಇದ್ದಾರೆ?
ಇಲ್ಲ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ಅದು ಬಾ. ಇದು ಬಾ. ಬಾ ಅಷ್ಟೇ.
ಬಾ ಅಂದ್ಬಿಟ್ರೆ ಆಮೇಲೆ
50-50 ಅನುಪಾತಿತ ನಿಯಮಗಳು ಅಂದರೆ ಕರ್ನಾಟಕ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟೀಸ್ ಅಲಾಟ್ಮೆಂಟ್ ಆಫ್ ಸೈಟ್ಸ್ ಇನ್ ವ್ಯೂ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್ ಫಾರ್ ದ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ಡ್ ರೂಲ್ 2009 ನಿಯಮಗಳು ದಿನಾಂಕ 30/7/2001 ಜಾರಿಗೆ ಬಂದಿದ್ದು ನಿಯಮ 3 ರಲ್ಲಿ ನಿವೇಶನ ಹಂಚಿಕೆಯನ್ನು ಲಾಟರಿ ಮುಖಾಂತರ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡ ಬಡಾವಣೆಯಲ್ಲಿಯೇ ಮಾಡತಕ್ಕದ್ದು ಎಂಬ ಅವಕಾಶವಿದ್ದು ಹೊಸದಾಗಿ ಕೈಗೊಳ್ಳುವ ವಸತಿ ಯೋಜನೆಗಳಿಗೆ ಈ ನಿಯಮಗಳು ಭವಿಷ್ಯವರ್ತಿಯಾಗಿ ಅನ್ವಯಿಸುವುದರಿಂದ ಈಗಾಗಲೇ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ಹಳೆ ಬಡಾವಣೆಗಳಿಗೆ 2009ರಿಂದ ಜಾರಿಗೆ ಬಂದಿರುವ ಮೇಲ್ಕಂಡ 50-50 ಅನುಪಾತದ ನಿಯಮಗಳು ಅನ್ವಯವಾಗುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಪ್ರಾಧಿಕಾರದಿಂದ ಬದಲಿ ನಿವೇಶನಗಳ ಮಂಜೂರಾತಿಗಾಗಿ 50-50 ಅನುಪಾತದಂತೆ ಕೈಗೊಂಡಿರುವ ಯಾವುದೇ ಕ್ರಮವು ನಿಯಮ ಬಾಹಿರವಾಗುತ್ತದೆ. That is the stand taken by the government that 50-50 allotment is subsequent. Now here in this case,
who has passed this order?
Government, my lord. It's passed by the government.
Not government, my lord.
In the name of his law, it is passed in the name of the governor.
Your lordship may kindly.
Now, my lord, let me complete, sir, if you don't mind. Now, my lord, all these.
My lord, all this is. I mean,
Wait, sir.
it's already been withdrawn.
Let
What's
him finish it.
Okay, let him.
You read the withdrawal order. He will read the order.
It's of
Yes.
and has no relevance to the case, my lord.
ನಾನು ಮುಗಿಸೋದೇನ ಇನ್ನು ಇಷ್ಟು
Sir, ಮುಗಿಸ್ಬಿಡಿ.
ಅಷ್ಟೇ ಇಷ್ಟು ಮುಗಿಸೇ ಬಿಡ್ತಾ ಇದ್ದೆ. The illegal allotments, not in favor of the petitioner's wife, the allotments.
That is in general in Muda.
Correct.
That is where a committee was constituted to go into the corruption in Muda. That is already told.
No, I am not on corruption in Muda, my lord. I am on the government stand with respect to the applicability of the 50-50 rules. The 50-50 allocation, even according to the government, I am on the content of this order, is post 2009. Here, my lord, all these sites were allotted in 2003. Therefore, the 50-50 would not apply for allotment in favor of the petitioner's wife, because the illegal encroachment was in 2003.
Sir, that's by a separate notification. We will consider that.
That's all that I am saying, my lord. This
I-
is a piece in the jigsaw puzzle.
Yes, sir.
Please, ma'am. Yes, ought to be, in fact, your lordship.
Where is the order of withdrawal, Kodi?
Your lordship may kindly see page number, my lord. Page number 12, my lord. In fact, my lord, what has happened pursuant to that, my lord, a representation was given by the said officer saying that these are factually incorrect statements have been made in the suspension order. That is at page 8, my lord. Pursuant to that representation, my lord, it was forwarded to the Department of Personnel, UD department. Then they sought for certain clarifications. Pursuant to that clarification, my lords, we have passed a fresh order of withdrawal of suspension that is dated, my lords, 3rd September 2024 at page 12. So in fact, my lords, having known, having produced this order, my lord, they ought to have produced the withdrawal order. They can't mislead, my lord.
The withdrawal order communicate ಮಾಡಿದ್ದಾರೆ.
No, we didn't communicate to the suspension order also, my lords.
ಅಲ್ಲ ಆಫೀಸರ್
Officer ಯಾರಿಗೆ communicate ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ ಮಾಡಿದ್ದೀವಿ. And it is between us and him.
ಅವರಿಗೆ ಪತ್ರ ಲಗತ್ತಿಸಿದೆ ಅಂತ ಏನು ಕೊಟ್ಟಿಲ್ವಾ?
ಏನಿಲ್ಲ.
Yes. All right. Yes, sir. Yes.
Lord,
Senior counsel has come. ಅವ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿ, ಏನ್ ಅರ್ಜೆಂಟ್ ಇದೆಯಾ? ಏನ್ ಹೇಳ್ಬೇಕಾಯ್ತು?
Written synopsis filed.
ಯಾರ್ದು?
Respondent number 3. Lord, one aspect, my lord, the earlier occasion.
ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀರಾ ಸಿನಾಪ್ಸಿಸ್?
Please.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ಅವರೇ, ಸಿಂಘ್ವಿ ಸರ್ ಆಮೇಲೆ ಪ್ರೊಫೆಸರ್ ಮುಗಿಸಿದ್ಮೇಲೆ ಮಾಡಿ.
Because there are some issues, but they are hard to answer.
Only 2 minutes.
Please.
You should also sprint in 2 minutes.
Please.
Yes, sir. Yes.
I thought it was.
No, it's finished. File kodi, madam. Main file kodi. So we're going to conclude this today, sir.
Yes.
Yes.
Wait, please, my lord.
Yes.
Whereas I am going to give your lordship say written submissions in the form of whereas extracts are also
Yes,
there.
sir.
Everything is in one place.
Yes.
And whereas I'm going to read some parts of it, but I'm going to whereas just develop the nuances of some principles of law. Your lordship may not find it in the sequence in which it is argued.